Lordship, may I permit, Lordship, day after tomorrow, my prostate cancer operation fixed. That is why I am mentioning on leave to file without certified copy, because next week I will not able to come. Day after tomorrow, Tata Center, cancer, Lordship, prostate cancer.
Get well soon, get well soon. When was the order passed?
Order in this is come from the interim order. July passed, but the file is in the court. That is why no certified copy is applied.
You applied.
Yes, 100%.
When was the order passed?
5th July. Because the file in the court, that is why not certified copy. Grateful,
You've
Lord,
done.
most grateful.
We hope that everything goes fine with you.
Prostate is, Lordship, January they alert me because I was not alert, Lordship. They come outside.
Don't worry, don't worry. Medical science has advanced. Don't worry. Yes. Leave the other. Call the list. কেউ আসেনি নাকি? জয়ন্ত আসেনি? কল করো।
Lordship, in item number 1, the advocate on record for the petitioner is suffering from fever. So I'm praying for not this week.
Lordship, I'm for the state.
What is the matter about?
Lordship, I am not associated with him. He has only requested me.
My Lordship, in this matter,
We are not passing order against you. Let us see what is the matter. Missing since 2017.
Lordship,
That is why he is not done. Who is the state?
My Lordship, in this matter, Miss Amrita Paja Mollik is appearing for the state. My Lordship, she is engaged in courtroom number 41.
Next Thursday.
grateful.
Grateful, my Lordship.
Please, Your Lordship. My Lord, as on this morning, my Lord, we've checked the service to the private respondents who are in Patna, my Lord, are not complete. This is a case, my Lord, where this is not a dispute between husband and wife. My Lord, the wife has died, my Lord, 14th of December 2021. The private respondents, my Lord, are the brother and the wife of my Lord, my wife. Now, my Lord, after my wife died, the family member said, for a time being, let your daughter stay with the uncle and aunt. Okay, no problem. Now, my Lord, they're refusing to hand back the child.
Since when she is staying?
Since, my Lord, December 2022, she's been with the uncle and aunt. Since June, the father has been requesting all the family members, sisters, brothers, uncles, my Lord, they are refusing.
So she has been taken to Patna.
Patna. And, my Lord, the reason I'm before your lordships, my Lord, we first approached the SDO.
Where was the child born?
My Lord, she was born on 30th of May 2021.
2 years old.
My Lord.
Born in Calcutta.
Yes, my Lord.
Your house is at Calcutta.
He's a Howrah.
When did your wife die?
My Lord, on 14th of December 2022.
Complete service.
My Lord, can I come back next Wednesday, my Lord?
Next
My Lord,
Thursday.
one indulgent, I'm praying. My Lord, what has happened, my Lord? Respondent number 1 will be, my Lord, the state of West Bengal through the, my Lord, government pleader. We have, my Lord, inadvertently, my
Not
Lord,
through the government leader.
my Lord, the office of the government pleader. My Lord, this perhaps needs to be corrected, my Lord.
It's a question of child welfare committee.
No, my Lord, it will be through the, my Lord, government pleader. The respondent number 2 is the SDO, my Lord. We, my Lord, file an application under
But
section
let us see,
97.
You complete your service.
My Lord,
and
can I
come
come
on.
back next Wednesday, my Lord?
Next Thursday.
Thursday.
Yes. Call the next.
Well, leave to correct the cost title, my lord.
ভুল করেছে অ্যামেন্ড করতে দিতে শুধু কনসার্ন, কিন্তু তারপরে এসডিও ডিএম টিএম সব আছে, স্টেট অ্যাপিয়ার করে যাবে। অ্যামেন্ড করতে বলছো তো সার্ভিস করেছে তো সেটা
Well, leave to correct the cost title.
we would have given, but the thing is you have already sent, na?
No, no, no.
You have not sent for service.
No, no, for the private opposite parties. Yes, yes.
Then the state authorities you have not
We,
sent.
we wrote this and we went to the government creators office. They didn't accept it.
Child welfare committee, another body.
Child welfare committee is a
My lord,
separate body.
my lord, it is my fault. My lord, it should have been the government creator.
That is it too.
Because we've not approached them. We've approached the respondent number 2.
As a non advocate, circumstance, place for liberty to amend the cost title. Place for leave করবে ঠিক আছে, leave granted. And he submits that the service upon the respondents have not been effective. Is the matter.
Thursday, next Thursday, the petitioner is directed to complete service in the meantime.
28. Next Thursday.
Next Thursday. Great.
My lordship, in item number 3, Mr. Devabrata Chatterjee sir is appearing for the state. My lordship, he is engaged in courtroom number 29. I'm praying for short passover.
Yes, who is for the petitioner?
My lord, I am for the petitioner. My lord, I am praying for short passover, my lord. My lord, senior is in another.
For the next. Yes.
My lordship.
I appear for the appearance. The last occasion, my lords have been pleased to direct the matter to appear today.
It's appearing.
My lord,
Along with কোনো ব্যাপার আছে?
on the other day, other side was appearing. The coal mines CMPFO, coal mines provident fund organization, as well as the principal employer. Eastern Coalfields Limited. Kindly have a look to my lord's earlier order.
Opposition file.
The
They have filed the
application, opposition reply,
No. In this,
there no opposition.
No, there was a direction for affidavit.
But no affidavit has, no affidavit is
filed.
forthcoming. At the time of admission, they appeared. And thereafter, last occasion, they appeared also.
When did you retire?
But in 2007,
2000
1/1/2007,
In 2012, you approached the court
my lord. Correct.
for switching over.
Not switching over. I am entitled to, after rendering 40 years of service, I am entitled to pension. That has been prayed for. That was rejected. No answer was given. Therefore, the writ application was filed. The affidavit forthcoming. In the affidavit in opposition, my employer, principal employer, admitted that 2% amount was deducted, but
For what?
returned
For what?
for pension fund.
2% amount was deducted.
Deducted. Regularly, it was deducted for pension fund, but it was returned back to the petitioner, appellant. But my case is this, it was never been
After your retirement.
after my retirement. During the
But
tenure
Mr.
of,
Das, how you can now agitate the issue? They have given you contributory provident fund.
no, that is not the issue at all.
No, you are saying it is an admitted case. You are an optee under pension scheme admitted by the respondents.
My lord.
Deduction was made.
Deduction was
understand.
made, but it was returned back, refunded back to the appellant.
Give a notice, come back on Thursday, let us see. Otherwise, we hear the matter ex parte.
My lord.
Next
Lord,
Thursday.
my client is in the deathbed. Now, that is why the urgency is there. May Lord kindly hear out the matter.
That is why we
My lord.
fixed it.
My
That is why we fixed it and we gave them a last chance. But they are not appearing. কি করবো তো? শুনে নেবো।
আচ্ছা, আমরা বলতে পারি বৃহস্পতিবারের যেখানে আপনি শঙ্কর
Mr. Das, you give a notice. Matter
Ma'am.
appeared.
Certainly.
We will again take it up on next Thursday. Affidavit in opposition, if they have not filed, if they filed in between, very good. Otherwise, we will not accept. We will hear out the matter.
As your lordship. Let it.
Or come on Monday. Intimate
Monday.
them.
Very good.
It
Now,
will
let it
be-
remain its retain its position.
It will be in the supplementary list. Yes. Monday হবে না মনে হয় 11টার সময় মামলা ফিক্স করেছে। Oh no, that is Friday. ঠিক আছে। Who are the advocates? You must be knowing.
My lord, I know. Sanchita Barman Roy is for the principal employer and my lord,
Give a notice. You give a notice to Son and Somosri Saha.
Somasri Saha, yes.
Yes, next.
Not fixing it on Monday.
It will be there in the list on Monday. Make a short list of dates and
Right.
come. Yes, next.
Grateful to your lordship.
I'm appearing on behalf of the respondent, I'm praying for a short pass over, my lord.
Item number 5, my lord, last occasion I paid time, my lord, on behalf of my senior Mr. Abrata Majumdar. He is out of station on that day. Today he is again requested, my lord, 2 days time is required. He is not ready in this matter. Monday he will do this matter.
It will be on combined monthly list of October. It
No,
is,
let
it is
it-
hearing, na? It is
No,
hearing.
not hearing, my lord. Only 1 day matter is hard. Only 1 day matter was hard.
Very good. Under motion, it will appear.
Lordship, kindly, I'm for the respondent number 4, Lordship.
Combined list motion hearing এ রেখে দেবে।
Next monthly list.
Next
Next.
monthly list.
There is no direction for opposition also. If they choose to file, there is pleadings is complete in the tribunal. Reply, rejoinder, written
Then
also.
no further is.
Lordship, my humble prayer is, could this matter be taken up next week, your lordship?
Yes, call the next.
Grateful. Next month.
এটা মোশন হিয়ারিং এ দেবে, বুঝেছো তো? কম্বাইন লিস্টে মোশন হিয়ারিং এ যেটা তোমার ইয়ে আছে, ক্যাপশন আছে না, দেখো কম্বাইন লিস্টে আছে। এই যে দেখো মোশন সেন্ট্রাল ট্রাইব, এটা দেখবে। ইয়েস, নেক্সট।
My lord, item number 6, I have for the appellant.
Yes, my lord.
Last occasion, lordship on 17th August 2023, lordship directed to me to serve this copy of this order to the advocate for this bank. I have served and this is the evidence of service. With the matter relating to this.
That bank loan, that bank loan,
No, my lord, not bank loan. The matter.
sanction of loan.
No, but it is dismissed. The branch
Aha,
manager
pertaining to distribution of loan.
loan,
Yes.
extremely.
Sanction of loan without any authority.
We will hearing.
Yes, my lord.
Yes.
And my lord, before starting, my lord, he has taken some points, which is,
পেপার বুক আছে, পেপার বুকটা দিও।
my lord, he has taken some point which was not as a subject matter of the read petition, and I strongly oppose to consider those.
We'll hear
Yes, my lord.
Let him
Time of your
continue.
turn.
এটা পেপার বুকটা দাও।
Lordship, this matter relating to the dismissal of this branch manager was posting at Bhavanibati branch, district Murshidabad. My lord, this
When
apple.
did we hear it?
My lord,
When did we last hear it?
last hearing of 18th.
17th.
Lordship, kindly see this page. At first, the page
দাঁড়াও।
305.
আরে দাঁড়। No, fine. মনে হয়নি। মনে পড়ে যাবে। কত তারিখ? 21 তারিখ না?
21, হ্যাঁ। না, আজকে 21 না 20, আজকে বুধবার, 20 তারিখ।
Writ petition was dismissed on the ground inquiry report was not annexed.
Lordship.
Against
Not
that
adjudicate-
appeal,
not adjudicate any merit of this case. Only that.
we are recapitulating.
Lordship.
Writ petition was released on, dismissed on that ground.
Lordship.
This division bench admitted the appeal with a direction to bring the inquiry report on record.
Lordship.
Have you brought it?
Lordship. All left out documents.
Huh.
Inquiry report also annexed.
Where is those? Where are those?
Lordship, kindly see this.
Paper book that is included in paper book.
Lordship.
Achha, very good. Yes, place your case.
Lordship, kindly see, Lordship, the page 503, paper book number 2.
Paper book number
2. Lordship, then your
সাহেবেরটা কোথায়? Yes, 503.
503.
What is 5? What is 503?
Lordship, kindly see. They are these 29 years dedicated, rendered his service as a employee of this bank. Lordship, kindly see that I am serving my beloved institution last 29 years. And initially he was appointed on 10th January 1979. And by virtue of his dedications and hard work, he was promoted and posted in several banks. Kindly see this.
Show us the charge sheet. You are challenging the proceeding.
Lordship, I am submitting, but
You have told us this.
it also necessary.
You have told us. On the last occasion, you have told us.
Lordship.
Now come to the point.
Lordship,
You start from charge.
good service ground. There is no negligence, no any other penalty regarding during the service period of 29
Mr.
years.
বিশ্বাস, if you
Lordship,
don't listen to us, it is very difficult to conclude the hearing.
Lordship. Kindly see, Lordships, that the main allegation is that this appellant had extended credit facilities 101.86 lakhs amount to these beneficiaries and these borrowers after withdrawing his loan sanctioning power. This is the main allegation. That charge is not applicable in respect of this appellate. I am submitting. Lordship, kindly see the charge sheet. From this charge sheet, I am again 1-to-1. I am submitting and kindly tally with this sheet, the charge sheet. Kindly see the charge sheet.
This charge sheet was, my lord, sorry to interrupt, my lord, this charge sheet was not the subject matter of the writ petition, and he should not be allowed to bring new.
Sir, you will get your chance.
Yeah, my lord, I am reading.
If you
Yes.
disturb, then we
No,
can-
I am not disturbing. I am
will
raising
get
initial
your
objection.
chance. He's not running away.
387. 387. Volume 2. 12 June 2007, charge sheet was issued.
Yes.
Kindly see. Lordship, there this 12 June 2007 charge sheet was issued. There are these 5 charges. First and main allegation is that the sanctioned credit facilities to the tune of rupees 101.86 lakhs even after withdrawal of your sanctioning power by the regional office Kolkata. This is the main charge.
Where
Kindly see
Where you are
page
reading?
388. The last charge 388, first paragraph. 388. Lordship got it?
Yes, what was the charge?
Charge, Lordship kindly see the charge. First charge is article of charges 387, page 387. There I am reading from the first. That you were working as a Bhawanibati branch manager at Bhawanibati branch during the period between the June 2005 to May 2006. And while you working in your positions, as such, you abused your official positions and extended credit facilities to certain parties in blatant violations of these bank lending norms, without proper pre-sanction appraisals of these credit proposals, without ensuring the end utilization of the loan proceeds, without proper post-sanction follow-up and control, and hereby unduly accommodate to these parties' concerns by exposing banks huge funds to the tune of rupees more than 102 lakhs to the risk of loss. Thereafter, the charge started. The first charge is that in the process, you extended credit facilities to non-existing units in connivance with middleman. First charge. And second charge is placed on record false post-sanction inspection report. And third charge, sanction a loan of rupees 1,10,000 in the name of a party without his knowledge. And the next charge, our fourth charge is misutilized the loan proceeds for yourselves, made several unauthorized adjustments from one account to another accounts, including your own accounts. And the fifth charge, very important charge, that is the main charge. That charge is not applicable. This charge is sanctioned credit facilities to the tune of rupees 101.86 lakhs, even after withdrawal of your loan sanctioning powers by the regional office Kolkata. This is the main charge. Lordship, kindly see this.
Now, this 101 lakh is included with.
But here this amount are also different. Are also that there are 86 lakhs are also different. Amount also differs.
86 lakh?
86,000, 0.86,000. Here this first leaks of loss 102 lakhs. 102 lakhs there.
That is included within this.
Within included. But here the loss is 101.86 lakhs. Lordship, kindly see in the charge sheet. There are these.
Again, Mr. Biswas, you show us the documents, then argue.
Lordship, I am submitting.
Please concise yourself. We are in judicial review.
I am concise, Lordship.
If you don't listen to us, then we will stop here.
Lordship, I am obeying Lordship's directions.
Yes. Show us the document. Show us the document.
Lordship, kindly see. With tally with my sheet, there are these loan sanctions. Kindly see these first loans, 21st January 2006. Kindly see it's the second page.
Where you are? We are on the chart sheet. What else you want to show us from the chart sheet?
From the chart sheet, page 388. First 388, first one, number one. That the when sanctioned, when the loan was sanctioned, that I also submitting before your lordship. Kindly see this. The 21st January 2006, in favor of there this Ziaul Rahman. Lordship got it? Ziaul Rahman. The 98,000. Lordship got it?
We have got it. We have got it.
Page number 388. Kindly mark my sheet. There the Ziaul Rahman finally mark in my sheet, the first one. And there the 20% are also present there. And second, the 23rd February 2006, in favor of Firoza Begum. In favor of this Firoza Begum, sanctions on 24th February 2006. 24th February 2006, 24th February 2006, in favor of this C. Bindabon Ghosh. Amount is 90,000. The FLDRE loan. Lordship, second page, FLDRE loan. They only 6 FLDRE loan. Ziaur Rahman and second Firoza are second. And this fourth, Indrajit Ghosh. They are the 19th August 2005. 19th August 2000, Indrajit Ghosh. 19th August 2005, 90,000. And second from the chart sheet, the fifth loan. Fifth loan, there this amount is They are the 90,000,
Where you are reading?
page number 390. On this 390. And tally with this my tabulation sheet. Second page, the FLDRE loan, only the 6. Second page, FLDRE loan. Lots. I'm extremely sorry, lots.
Yes.
And the fourth is Indrodit Ghosh, the 19th August 2005. The amount is 90,000. And fifth is the Muhammad Ahsan Ali, 24th February 2006, sanctioned and disbursed. And the sixth was Bhutnath Ghosh. Their amount is 90,000 on 24th, on 3rd March 2006. This sanctioned and disbursed. In the sixth DRE loans, kindly see this FLDRE loan. That the sixth FLDRE loan total amount is the 5,33,300. 5,33,300, and it was disbursed. Date is tally with the charge sheet. All these dates: 21st January 2006, 24th February 2006, 27th February 2006, 27th February 2006, 3rd March 2006, and 3rd March 2006. This loan was sanctioned and disbursed. And second, kindly see this first sheet. There are these loan sanctions. The first number 1, Bolai Ghosh. Kindly see this, the Bolai Ghosh. Loan was sanctioned on 16 July 2005. 16 July 2005.
That is number?
Bolai Ghosh, number 1.
Bolai Ghosh, where do you find?
Where is it? 391. 391 page, kindly see, Lordship. 391, last paragraph. 391 page. Last paragraph, that is 16th July 2005, 3 lakhs in favor of Bolai Ghosh. Lordship, got it? These are the my tabulation sheet, serial number 1. Kindly mark it. And second, number 2, that number 2 SODAs, there Putul Ghosh, that disbursed sanction on 4th October 2005. Lordship, page number 392, 4th October 2005. Lordship, kindly marked it this number, serial number 2 in my tabulation sheet. And second part, ODA is the 7 lakhs on 7th October 2005. 7th October 2005. Pawan Kumar Ghosh. And next, ODC Ratan Kumar Ghosh. Disbursed on sanction 21st July 2005. Kindly tally with this number, serial number 4. Serial number 4. And second, the SODA is in favor of the Pawan Kumar Ghosh. The amount of 9.5 lakhs, 8 October 2005. 8 October 2005. And next,
all right.
Lordship, all these
to the show us the inquiry.
all the charge sheets. Lordship, kindly see all these loans are also sanctioned when they had sanctioned in favor of these borrowers and these beneficiaries. They are also tabulated in my sheet. But here this point is that after withdrawing the sanctioning power, the manager extended this loan. These are the main allegations. Kindly see this documentary evidence. On the basis of the documentary evidence, when this loan sanctioning power was withdrawn. Lordship, that issue is main issue. Kindly see the page 77. My paper book number 1. Page 77, paper book number 1.
The একবার এখানে যাবে, একবার ওখানে যাবে, একে সামলানো।
না, দুটোই লাগবে।
77, my lord. Lordship, got it? 77?
Yes.
My lord, that the 20 October 2005, there the subject of this letter, non-submission of the AB 1026, June, July, August, and September 2005. On the process note, how much amount had extended by this manual, that report also submitted to the RO office. That letter, there is not subject matter is the others. But last paragraph I am submitting before your lordship. Kindly see, in view of this above, we advised you to submit this AB 1026 along with these process notes in respects of this loan more than 1 lakh in persons on 24th October 2005, failing of which this matter will be placed before this competent authority for initiating disciplinary action against you. Again, you are instructed not to sanction or release further loans until we accord the clearance for this purpose. This is the first letter. The 20 October 2005, this date is very marked. And second letter, the 7th March 2006, kindly see the next page, 78. Next page, 78.
So from 20th of October,
My lord, 20 October 2005.
we advise you to submit such and such along with the process in respects of loans more than 1 lakh in person on 24th October.
Lordship.
So the loans you gave,
91 lakhs prior to that.
some
91.
of the loans, some of the loans were prior to that.
Next paragraph, 98. Next, 78, kindly see. 78. 91 lakhs already extended prior to that. 10th October, 20 October 2005.
What is this AB 106?
One AB 106, the process note, my lord.
Eh?
The process note, how much amount, how much loan was sanctioned
So
by the
how does this prove that you had the power to disburse loans prior to 24th October 2005? This letter says that you submit the AB account,
lordship? I am
and from 24th October, you do not sanction any further loan.
lordship.
On this basis, how do you say that prior thereto you had sanctioned?
Lordship, I am submitting. Lordship, kindly see the next letter.
No, answer our
The
issue.
answer is that this manager itself is delegated power to sanctioning this loan until and unless his delegated power are withdrawn by the deputy general manager or the general
Who
manager.
was that provision? Where
Position,
is
kindly see this provision. Next paragraph, page number 79. Page number 79. Page 79, kindly see. Last paragraph.
You are in the habit of
I am placing my last one.
viewed seriously.
19 May 2004.
Then
On the basis.
just a moment.
Lordship.
না, এটা তো সাসপেন্ড করলো মানে হি হ্যাড দি অথরিটি। তাহলে তো সাসপেন্ড করলো 7/3/2006 তার আগে তাহলে তো ইয়ে ছিল। Your sanctioning powers to grant loans shall remain suspended.
This
Your
letter dated
loan sanctioning power was suspended.
on 7th March
7th
2006.
You are trying to state that before that date you sanctioned this law.
My lord, absolutely correct, prior to that, before that. And lordship, kindly see when this sanctioning power was withdrawn on the basis of the circular, kindly see the page 79, 18th March 2006, page 79. Kindly see, I am placing before your lordship the last paragraph. May I placing, my lord? That the now.
What was your tenure in that branch? From when till when you were there? In this branch, you were
my tenure, lordship, my tenure in this branch is the duration 29th May 2005 to 30 July 2006.
29th May
29 May 2005 to 3rd July 2006. That was not reflected in this charge sheet, order of the disciplinary or the order and the order of this appellate authority. Gross illegality, Lordship. I am submitting before Lordship. Kindly see the when this loan sanctioning power was withdrawn. Last paragraph I am placing before your Lordship. Now, upon going through the report, it is decided that further exercise of this delegated loan sanctioning power by you will not be in the interest of this bank. I therefore, in accordance with these powers conferred on me by circular number such and such dated 19th May 2004, same power, am withdrawing this loan sanctioning power delegated to you in terms of this credit sanctioning power circular such and such dated 19th May 2004 with immediate effect until further order. You are also advised to take all the steps necessary so as to protect this bank interest and to ensure that none of the advances sanctions by you become NPA or irrecoverable. So this 18th March 2006, the loan sanctioning power was withdrawn. Prior to that,
Show us the imputation pertaining to that charge. 388. That the charge was that you have disbursed loan of 1,01,86 lakhs after withdrawal of your sanctioning power.
my mind.
Where is the imputation to this charge? In the charge sheet?
Lordship, kindly see the page.
Have you understood my question?
Lordship.
Show us the imputation pertaining to that charge.
387.
বলছি এটাই নেই লোনেরও ডেট দেখাতে চাইছিল যে 7/6 yes.
Where is the imputation, Mr. Vishwas?
Imputation specifically not explained, but on the basis of this, all these loans, all the loans and beneficiaries' name are also computed in the charge sheet. And
you will not allow us to make queries. Page 388.
388.
See, in bold letter it is written, statement of imputations of misconduct on your part.
Lordship.
So you have read the charge sheet.
Lordship.
Show us that portion.
They are not explained in that way.
All right.
Not
that way or that way, we are not asking you. We are asking you according to you. Is there any imputation to this charge?
All this loan, they are imputation. The imputation is that all this loan.
There is an imputation that you have sanctioned loan after withdrawal of power. What is the imputation to that?
I am understood before these queries of my lordships, but in the charge sheet as well as the inquiry form, there is no explanation, no imputation in the charge sheet.
All right.
That the loan sanctioning power was withdrawn, and the manager had extended 1,01,01 lakhs after.
Next, what you are arguing?
Lordship, kindly see this main charge is that they are not extended these powers before.
You are arguing in appeal respect of disciplinary proceeding.
My lord.
We are not going to go into the appreciation of evidence.
Lordship.
You will show us on the face of it, it is bad. Show us from the inquiry report that the charges have not been proved.
Lordship.
Take us to the inquiry report,
Lordship.
300 pages inquiry report.
Lord,
have you made your homework?
Lordship.
Yes, show us.
Lordship, kindly see this inquiry report. Kindly see. In the inquiry report,
show us that portion by which the inquiry officer held you guilty in respect of the charges.
Lordship. In respect of the charges, Lordship, kindly see this page.
Where is the inquiry report?
Inquiry report page 475 start. Inquiry report 475, the charge is the defense officer not asked that the how the 1,01,000 amount
manage kora very difficult. Very difficult.
You just
Mr.
Lordship, this is the inquiry report.
You just show the last operative part of the inquiry officer and the punishment, then we are coming to you. What inquiry officer held?
Guilty.
Page.
The inquiry report page 475, start from 475. 475. The gist of this article of charges, 475.
Yes.
475 in
The charge. They are at a glance.
narrated such and such.
Narrated such and such.
We want to know his findings, operative part of his findings.
Findings, operative part of this finding in respect of the charge number 5. They are not finding at all. But again and
Where is that?
again and again, he also appealed before this authority concerned.
Okay, you show us.
That questions are not submitted by these defense officers at the time of inquiry forum.
Maybe what is,
There is specific questions regarding the charge number 5. They are also overlooked again and again against this defense, against this inquiry, defense of this inquiry report. Kindly see, Lordship, these my defense submissions against the inquiry report. I am submitted. Page 491.
that's coming. Sanction. ODH OSL account to the parties without their.
My lord, I am just helping the court, my lord.
Please keep take your seat.
My lord, one thing, my lord, it is relevant. Inquiry report is, he has annexed, it is not in final. My lord, after 50, page number 15, there is page number 18. My lord, see, 489 page, it is inquiry report, page number 15. My lord.
All right, you will show it to us. You will
Yes,
show it.
and entire inquiry report has not been annexed.
Where is the inquiry report?
Yes, my lord, that
You
is.
have the inquiry report.
Yes, that was the objection I was raising in the initial. Inquiry report was not the subject matter before the read court. And my lord, it is settled principle of law that whatever document and points has not been taken before the read court cannot be taken at the stage of appeal, my lord. And my lord, he has added all this thing in the appeal. And my lord, he has annexed the inquiry report, page number 489. It is showing inquiry report, page 15. My lord, see, 489.
Yes.
Page 15. And my lord, 490, it is page 18. Where is in between pages?
Show us. Inquiry report is your document.
No, my lord, as it was not.
Bring the inquiry report.
Yes, my lord, I will inform my client. At present, I don't have the inquiry report. My lord, I have to collect from my client.
2 pages or
Where are the remaining?
No,
4
2
pages?
Is the main observation of.
Yes, my lord.
But
My main
two-
observation portion has been.
pages.
That was I was trying to assist the court.
My lord, the
The
2 pages
observation
are also
portion has
missing
been
at the time
How-
of
how
paper.
can-
But only the 2 pages. I am also down. This
Show us those 2 pages.
then,
Internal page 16 to.
nothing. একটা copy আছে।
Internal pages কত এটা?
I am admitted.
15 after 18.
16, 17.
16 and 17. The back sheet at the time of Xerox, it was BC.
হ্যাঁ, ঠিক আছে। Give a copy to him.
Lordship. Copy দিয়ে দিচ্ছি। চিন্তা নেই। দিয়ে দেবো। কিছু নেই ওতে।
আরে না থাকুক, আপনি তো annex
আরে ও
করেছেন।
ভুল হয়েছে Xerox
তাহলে?
করতে। ঠিক আছে, যা, পরে বলছি।
আপনি এইবার সাবমিশন করছেন।
The fact that you gave loan of 102 lakh, this fact is not deniable. You have given the loan. Now, how the loan was utilized? Did you obtain the utilization certificate?
Utilization certificate, loan is
Mr.
Sanctioned.
বিশ্বাস,
Huh?
sanctioning power, forget it.
Okay.
Admitted fact, you gave loan of 102 lakhs. Then in the inquiry report, what you have submitted as regards that?
As regard that, at the time of inquiry report,
Hmm.
the defense officers are not asked to this inquiry forum in this management witness, these, how many loans are extended before withdrawing in the sanctioning power. This type of question are not asked. He is deprived. The employee is totally deprived. So in that case, I am submitting before this writ court when this, after 3 years, writ was admitted, the Honorable Justice Korgupto.
Show us your reply to inquiry report. Show us your.
Lordship, kindly see this. The inquiry report against the employee, page 491. 491, on dated 28 July 2008. Book number 2. May I place him, my lord?
No. We will go through.
492. Paragraph number 3, kindly see. It is alleged, Lordship, 492, paragraph number 3.
What were the exhibits from M1 to M334? Those
Yeah.
documents were collected.
333 is the documents of 3rd June 2006.
Uh-huh.
3rd March 2006. That is the 386. 3 MX. They are this exhibit number 383 is the documents of 7th March 2006 documents. That is the withdrawal of the sanctioning power. But regarding that, there is no queries at all before this inquiry. When this loan sanctioning power was withdrawn, that type of adjudication not done.
All right, admitted. Suppose it is not.
Lordship.
What about the other charges?
Lordship, kindly see this. This is paragraph 492. There that the defense, that totally deprived. Kindly see this paragraph 3. It is alleged 492. Kindly see, Lordship.
We are asking you a question.
Lordship.
Suppose charge number 5 they could not establish. Then how do you wriggle out of charges 1 to 4?
1 to 4.
Hmm.
That they are non-existence. They first either they are extended credit, especially in favor of the non-existing units.
Hmm.
In respect of this agricultural loan, that is the 6th agricultural loan, 5,33,300. Lordship, kindly this is in favor of the 6 beneficiaries. These associated with these livestock development officer, Samsherganj district, Murshidabad, my lord. These are the combined loan. And they are the BDO, block development officer, and the dignitaries of this Panchayat Samiti, all are this involved. And in the loan mela, these passbook are also distributed, sanctioned passbook distributed to these beneficiaries. that are the agriculture beneficiaries loans. And Reserve Bank are also circulated all these nationalized bank to increase the number to the beneficiaries in agricultural loan. My circular also available here. So in this agricultural loan, this manager is not extremely liable on this thing, but he also extended this credit facility within the sanctioning power, not after withdrawing the sanctioning power. Kindly see this, Lordship.
You
This
Coming to.
you were the manager.
my lord,
You were the manager. There is no dispute that this amount of loan was sanctioned by. There is no dispute. What you are disputing, you are saying that the responsibility is not my sole responsibility. This was done by me on the basis of the BDO, Panchayat members and everybody. So the liability cannot be directly upon me. This is your contention.
no, my contention is not that.
Then what is your
Contention is that within the sanctioning period,
আবার ওই কথা বলছি। We are assuming you are right, that you had the sanctioning power.
Lordship,
Now, whether you have misutilized such sanctioning power, that is the subject matter of charges 1 to 4.
that is the technical mistake, not this misconduct. Within the misconduct, I am submitting by Lordship Supreme Court judgment. The Virendra Prasad, Supreme Court already held that. Kindly see this paragraph, Lordship.
Supreme Court will come later, satisfy us from the facts. It
Lordship,
is admitted you sanctioned the loan.
Lordship,
It is an admitted fact that 102 lakh loan was rupees 200 was sanctioned by you.
Lordship,
Your contention is that I cannot be held responsible for such sanction. On what basis you make that submission?
1 lakhs are not responsible. I am within the sanctioning period, 91, all these loans are sanctioned. And this only the mistake is that the technical, not within the misconduct.
All right.
Technicality not within the misconduct. It was held by this.
Was your reply to the inquiry report, what you are showing, page 475?
Lordship, kindly see this page.
475,
Lordship,
paragraph 492, page, paragraph 3.
paragraph 3. Paragraph 3, Lordship, it is alleged against me that I have sanctioned loan credit facilities to the tune of rupees 103.71 lakhs, even after RO Kolkata advised me not to sanction any credit facilities without their prior clearance. I beg to draw your kind attention to MEX 383 RO Kolkata, letter reference number 425 such and such, dated 7th March 2006, wherein my sanctioning power was withdrawn on the 7th March 2006, wherein all these loan mentions in my charge sheets were sanctions earlier to 7th March 2006, and the same was duly brought to the notice of this inquiry authority during my defense statements, reference page number 553 of this inquiry proceedings, reply to this question number 3. The inquiry authority did not verify the date of MEX 303, 7th March 2006, but preferred to observe the defense could not bring any evidence on record to refute the charge during the inquiry. This is the plea. Defense could not bring these documents at the time of inquiry forum as such. These refute the charge, refute the charge is the admitted fact, admitted documents. There's a 7th March 2000, but here this plea, the inquiry forum, their plea is that, Lordship, kindly see this, the defense could not bring any evidence on the record to refute the charge during the inquiry. Here not.
Where you are reading?
But kindly paragraph 492.
492.
492,
defense?
paragraph 4.
Yes.
492, paragraph 4. First paragraph.
Yes. Now
Next.
kindly come to the disciplinary authority order.
Now order
Discipline,
of punishment, take us to order of punishment.
Order of punishment, a dismissal of service for this forfeited of this future service, forfeited of this provident fund amount. The hard punishment, not proportionate with the penalty.
show us that. Show us what was the punishment.
No, not proportionate with this misconduct. Kindly see this. The appellate authority order of
No,
the
no, come to the
Appellate authority
disciplinary
has
authority.
later on. Order of punishment, take us to order of punishment first.
19th August 2008,
19 August 2008,
page 496.
496. I wonder. Let's kindly see. In the process, he extended credit facilities to non-existing units in connivance with this middleware, placed on record on fall inspection report and sanctions, loans, 1 lakh parties, etc. Several unauthorized sanctions, credit facilities to the tune of rupees such and such loan amount after withdrawal of the sanctioning power by regional Kolkata, committed various irregularities in the such and such. Considering these, all these above aspects, circumstances of this case, I pass this following order. For piece of regulations of 3 sub-regulation 1, read with the regulation 24 of the Syndicate Bank Officers Employee Conduct Regulations 1976. The Robipada Murmu be and is hereby dismissed from service of this bank with immediate effect. If he so desires, the Robipada Murmu may prefer an appeal against this above order to this appellate authority. Lordship, here this order is that this employee is totally penalized. The order is totally wrong. This purported. I am submitting before your lordships this against the illegality and impropriety of this order. That is the adjudicated by this honorable court. The power of this honorable court.
Kindly come to page 498, read the last paragraph. 498.
498 last paragraph. I have perused all these paper, documents, materials concerned to this case, including his submissions by letter dated 28 July 2008. He is taking a stand that he is ignorant and he lacked knowledge of advances. He ought to realize that these has sanctions, extended loans amounting to over rupees 1 crores, which is under risk of loss. His extension release of these loans, which are under risk of loss. His extension release of this loan, even after withdrawal of these powers, ought to have the cautions his futures and this stopped release to further loans, which he did not, but takes the stance that he released as they were sanctions by him earlier to withdrawal of his powers. When he says that this RO has not taken note of sanctions on flimsy grounds, he stands that he lacked knowledge in advances in unbelievable government-sponsored schemes of this video recommendations are this.
Acha, your tenure, your loan power was suspended from 7th of March 2006.
Suspended, but not withdrawn.
Yes, 7th of March.
7th of March 2006.
Now, from the chart which you have given,
Yes, prior to that, all these loans.
yes,
All these loans prior to that.
come to the appellate authority order.
Finally, to the appellate authority confirmed.
Page
Lordship, this order of this appellate authority page last
505.
Lordship. $505. There this MW2. Lordship, kindly see this there.
What is the date of this order?
This order was 30 December 2008. 30
13
December,
December.
505. 500.
December 2008.
8, my lord.
Pre-sanctioning power ছিল, এটা কিন্তু ডিসঅ্যাপ্রুভ করতে পারেনি। ওর যে স্যাংশনটা সাসপেন্ডেড হয়েছে, স্যাংশন আগে ছিল হাতে, ক্ষমতাটা ছিল, সেইটাও ডিল করতে ডিসিপ্লিনারি অথরিটি সেটা শুধু এইটুকুনি বলেছে।
My lord, another important,
Will you keep quiet?
lord. I am extremely sorry, lord.
In response, যেটা দেখো 497 এ যে ডিসিপ্লিনারি অথরিটি অবজারভেশন। In response, Williams made his submission by stating that the report of the inquiry officer is not based on the record such and such. He has framed on preconceived without going through the details. Though it was alleged in the charge sheet that he sanctioned loans even after his sanctioning powers were withdrawn, all the loans referred to in the charge sheet were sanctioned prior to the issue of the above letter, which was brought to the notice of the inquiry authority during inquiry with evidence, which was dated 7th. Without recording the same, the IA observed the defense could not bring her to refute the charge during inquiry, which is against law. এবার ওর ফাইন্ডিংটা হচ্ছে এটা তো ওর বক্তব্যটা করতে হচ্ছে। In view of the above request, Hon'ble perused all the documents connected, including his submission, otherwise taken a stand that he was ignorant and lacked knowledge of advance. He ought to realize that he has sanctioned loan amounting to 1 crore. His extension stroke release, even after you ought to have been cautioned. Ought to have been, even after we ought to have been conducted his future and stopped release of further loans to which he did not. এটা কি করে হচ্ছে? এই ফাইন্ডিংটা তো ভুল, কারণ ও লাস্ট লোন যেটা স্যাংশন করেছে সেটা হচ্ছে প্রায়ার টু 7th March 2006। সেইটাতে একটু জল ঘোলা আছে। Come to page 508.
508. What are the MW2? Last paragraph.
MW1
MW1.
had deposed in details of the inquiry that appellant sanctioned and released 6 dairy loans without proper pre-sanction scrutiny.
Lordship.
NMB
Pre-sanction scrutiny, appraisal of these proposals, and without following these guidelines of the instates had created proceeds to the AB accounts of these borrowers, enabling them to the misutilized or misappropriated of these funds and kept false visit reports on records, etc., etc. That as the technically, that is not within the misconduct. Not within the
come
misconduct.
to the next page.
And Lordship, another thing is very important. Very important, another thing, the MW1, Anilesh Roy, and the MW2, there is Swarupananda Pramanik.
Come to the next page, page 509.
509, Lordship.
Advances were made by
Advances
and
were
confirmed.
made by the appellants and confirmed that the units were non-existent.
Right. So you have sanctioned loan in favor of units which were non-existing.
Lordship, I am placing before your Lordship.
What you are
The
placing?
MW1 represented before this inquiry from all this report without investigating of this unit. I am submitting, I am satisfied before your Lordship. Kindly see this page
Show
number.
us any document that those were existing on the date of sanction of loan. The units which their allegation was that those units were not existing at all.
Existing at all, in that sense, Lordship, this is a cow. He purchased this cow. This cow, after purchasing the cow, if this cow is whip out, then the unit is existing. But the human being, he also you out after 4 days or 5 days. These are the existing in respect of this, the FLDRE loan, 6 FLDRE loan, 5 lakhs, 33,300. That is the non-existing. There is no clearing system. As such, the directly to the seller or this vendor who sell these cows, directly check not given to the seller. In this Bhawanipati branch, the rural branch, there is no clearing system, and that at that sense,
আর চার্জটা হচ্ছে নন এক্সিস্টিং, পোস্ট স্যাংশনিং মেমো করে ওটাকে জাস্টিফাই করার চেষ্টা করি। Unduly accommodated parties in the process extended to non-existing units in connivance placed on record false post-sanction inspection. Yes.
only single branch officers and this authorized officer has no authorized, only one clerk and one branch manager. They are running this Bhawanipati branch rural, heavy pressure. So in the post follow-up sanction, pre-sanction appraiser, it is not properly done. I am submitting before your lordship. There are these small deviations are also taking place. That is the technical in nature. Kindly see this Birendra Prasad judgment passed by the Supreme Court. Another thing is that lordship, the MW1 in these proceedings, MW1 and management W2, MW2, two witness. The MW1 not investigating these units, all these units, he submitted without investigating the unit before this inquiry forum and inquiry proceedings. He submitted this report. I am satisfied before your lordship. Kindly see the page 464 or the paper book number 2.
Yes.
464.
Yes.
464. Lordship, kindly see these at the time of cross examinations, the MW1 is the Anilesh Roy, vigilance officer, senior vigilance officer.
Are show us the question.
Lordship, I am placing lordship. The 18, question number 18. Sir, you have alleged in your depositions that the visits of this place of address confirms that these business units of Sri Bolai Ghosh and Putul Ghosh are non-existent. 11 and 12. Please inform this inquiry from which address did you visit to verify the existence of their business. In place of address mentions in these loan applications pertaining to Sri Bolai Ghosh and Putul Ghosh were visited during investigation along with Sri S.N. Pramani, branch managers, Bhawanipati branch, exhibit number MEX number 69. The address mentions was village Nichindapur and Simantapur district Murshidabad. This was the address of this shop and this business mentions in the loan application as well as these process notes of Sri Bolai Ghosh and this Putul Ghosh. And this next, Lordship, kindly see this answer in this next. Lordship, he visited that.
He visited and he found that there was no such.
Kindly page 465, next page. Next page. I, Swarupananda, please. Are you aware of any investigations to credit irregularities conducted to you branch during your tenure? Yes. Sri Anilesh Roy, Sri Manager Vigilance and Sri Aniruddha Mitro, Manager Vigilance from Vigilance Units, RI Kolkata, had conducted and investigations into certain credit irregularities of our branches on 30 such date and also accompanied his Mitro to these borrowers.
Yes.
Let's kindly see the next question. I saw you certainly exhibit them on a max. What is this present status of this matter? They are only the Aniruddha Mitro, only accompanied the Aniruddha Mitro, only accompanied. Kindly see this next one. Only the Aniruddha Mitro was accompanied with, kindly next page.
So what is the wrong in that?
Wrong in that this Anilesh Roy is not visited these investigation units. The unit are not visited by the Anilesh Roy. But
That was done after your tenure was over.
no.
That was after your tenure was over.
After tenure was over, but the investigation officers, if not visited these units,
Where do you find that he has not visited?
he has not visited the MX 69. That only the signs of this Aniruddha Mitra, not the Anilesh Roy. Only sign when they asked by the
So
defense.
you are saying that there was no such inspection?
No, sir. Without inspection, he submitted this inquiry for us.
All right. He has come to the order impugned now. Where is the High Court's order?
High Court's order, Lordship, kindly see this. High Court's order.
Page 460.
Page number 8 of paper book number 1.
Yes, what page?
Page number 8, my lord. Paper book number 1.
Page number 8.
My lord. 18 March 2022.
Yes.
Lordship got it. I am placing my
All right. And this need not be placed.
Lord.
Yes. Yes. Yes, Mr. Khan.
My lord, first of all, my lord, I am raising preliminary objection regarding charge sheet and other documents, which was not the subject matter of the writ petition, and it was added at the stage of appeal, and this is unusual, my lord.
Show us the prayer of the writ petition. Writ petition prayer.
Yes.
That is at page 145.
Yes, ma'am. I'm coming. Yes, my lord. And my lord, after filing this writ petition in the year of 2010, he has filed supplementary affidavit upon the direction of the Honorable Writ Court, and even at this stage, he has not added all this inquiry report and the documents. Now he is placing before this court, before the Writ Court.
No, he has challenged the proceedings.
Yes, but my lord, but that ought to have bring down to the notice of the court, my lord.
Not required. We enjoy certiorari jurisdiction. We can call for the inquiry report.
Much obliged.
Order is not sustainable. Your writ court order has to go.
Yes, my lord.
Because the court said, since you have not annexed the inquiry report, I will not entertain your petition.
Yes, madam, he has given ample
Not
opportunity.
required. I will issue a writ of certiorari bringing the records.
Yes, my lord, if your lordship so
Exactly.
direct,
So the court deprecated. So the court said that I will not consider since your inquiry report is not here.
yes, my lord, even after giving ample chance, man, he has intentionally not added that inquiry report before the writ court. Even in the supplementary affidavit also.
Now, Mr.
Yes, my
Pal,
lord.
that
My
point
lord, I'm coming, my lord.
That point goes because
Yes, my
the
lord, I'm
applicant has-
coming. My lord, I'm coming. The main objection of my learned friend is that whatever loan sanctioned by him, he sanctioned after the.
Just one moment.
Yes.
What was the punishment ultimately? Sorry, I missed it.
Removal from service.
Page 505.
major plant report. Regulation.
Dismissal from service.
Yes, my lord.
He has not, you have not paid the provident fund amount?
Most probably not. I don't have specific instruction to this effect.
Forfeited, later also.
My lord,
Later also annexed along this, they are forfeited the provident fund amount.
Where is that paid?
Lordship, I'm finding and.
Yes.
yes, my lord, the thing is that my submission before your lordships are that whatever loan sanctioned by him, that was sanctioned after the withdrawal of his sanctioning power. He intentionally omitted 2 letters issued by the authority, and he placed before the court that as if his sanctioning power has been withdrawn in the year of 2006, but it is not correct. My lord, come to my affidavit in opposition, which is in page 222 of volume 2 of the paper book.
No, that
My
is
lord,
page 290.
Yeah, 290. My lord, I am just showing the order that is 2 annexure which was I added. It is 331, 331.
You are Canada Bank.
Yes. Actually, the issue was that
No, tell us.
I'm giving short. His dispute cropped up with the syndicate bank. Didn't syndicate bank. But my lord, after the amalgamation of in the year of 2020, that syndicate bank is no more existing, and it has merged with Canada Bank. And my lord, I came into picture in the year of 2020 only. My lord, 4/3/2020. My lord, on that date, the amalgamation taken place. My lord,
That part completed.
Daro.
Yes.
Yes, my lord, I am placing page 331.
But the disciplinary proceeding was concluded prior to such amalgamation.
Yes, everything concluded. Everything. Just I am stepping in the shoes of syndicate bank. Nothing more than that. No violation has been done by
Mr. Pal, show us that he had no sanction.
Yes, that I am placing.
Yes.
Come page 331.
We are on that page.
Yes, my lord, and the last line, my lord. It
Yes.
is dated 2010-2005. My lord, again you are instructed not to sanction
Where you are reading?
oblique last line. Last line.
Yes.
In view of the above, that is the last line. Again, you are instructed not to sanction oblique release further loan until we accord clearance for this purpose. It is on 2010-2005, not as he said in the year of 2006. My lord, that is a series of letter has been sent from the zonal office to him not to sanction the letter. But in spite of that, he has sanctioned again and again non-existing unit, my lord. My lord, and the next page.
Just one moment, Mr.
Yes,
Pal.
yes.
Please tell us.
Yes.
What does this line mean? This line means you have the sanctioning power, but you should not sanction.
Yes. Instruction is given
Not to sanction.
not to sanction.
Suppose,
Sanctioning power already lies with the branch manager.
yes.
Branch manager. But
Branch manager was
Yes.
asked not
Yes.
to disburse
not
any
to disburse any further loan.
Show us how many loans were disbursed after 20th of October.
All the loans, my lord, see the dates, and my lord, please come the next page, my lord.
20th October, you said don't do it.
Yes, my lord, please come the next page also.
And next page we are coming.
Just-
We are trying to ascertain. So 20th October, then the chart which he has given,
Yes.
chart which he has given, he has sanctioned from 24 January 2006
Yes.
to 30. After after this, these dates were after 20th of October.
Yes, my lord. And my lord, the very next page, my lord, 332. My lord, the sanctioning power always remains with the branch manager, but due to his activity, the authority concerned instructed him not to sanction any further loan. But in spite of that instruction, he's continued. My lord, next page. My lord,
Please
330.
answered a question.
Yes, my lord.
Then in chart sheet, why do you say that you had no sanction power to sanction?
Yes, power to sanction, it means that during the period he has sanctioned those loans, that time he has no power to sanction. It implies that during the period he has sanctioned this loan, that time his sanctioning power was withdrawn by the authority.
So your case is on October 2005, it was withdrawn.
Yes, my lord.
Then
My lord,
what
my lord,
happens- Then what happens about the loans which were sanctioned earlier?
my lord, regarding
He had sanctioned the loans from July 2005.
yes,
Your restriction was imposed on 20th of October.
October 2000, yes. My lord, actually he has sanctioned some loan. There was allegations against him, and it came before the authority concerned. And after considering those allegations,
Without sanction.
up
সব কটা লোক ওই কথা কিন্তু আগের কথাটা চুজ করতে হবে
and my lord, can you please come the next page?
নেই কি
2010 আগে আমি দেখি। সব 2010 আগে। Only 5 লাখ আর 11 লাখ।
And in the my lord, next letter dated 1/12/2005, there also same thing repeated by the authority not to disburse the loan in the last paragraph.
page
332. 332. Just next page of that previous letter. 1/12/2005. You are advised to exercise restraint in entertaining fresh proposal until such time we accord clearance. However, in exceptional cases which merit sanction, such proposal notes shall be sent to us in advance for clearance and sanction prior to their disbursement. My lord, his power has been temporarily withdrawn by the authority. My lord, he has sanctioned so many loans. My lord, so many allegations against him was brought before the authority, and considering those allegations, my lord, authority has withdrawn his sanctioning power, issuing one after another letter. And what letter he has referred before this court as if his sanctioning power has been withdrawn in the year of 2006. It is not correct, my lord. Before that, his sanctioning power has been withdrawn, but he intentionally avoiding those portion, he is placing the case that he has sanctioned all the loan prior to the withdrawal of sanctioning power. It is not correct, my lord.
No, kindly come to page 77 then, the letter which he was relying.
Yes. Yes.
He relied upon this letter.
Yes, my lord.
Upon review of statement, it is observed that you are in the habit of signing without following basic. Please note the matter has been viewed, and you has been advised to inform you that your to grant loan remains suspended with immediate effect.
Yes.
That is from 7th of March 2006.
Yes.
And the letter at page 331 was 20th of October 2005.
And my lord, the next letter which I have referred just now, he has not, yes, 1/12/2005, that letter he has not annexed.
এই যে annex করেছে তো 332
332, that is the part of my affidavit in opposition.
very
Yes,
good.
yes, my lord. My lord, in
So
the,
your contention, Mr. Pal, is that as he was the branch manager, he can sanction loan, but there were
yes,
irregularities.
usual power is
He
there.
asked him to stop
Yes,
from October.
yes,
2000.
yes, for
But
the
in-
time being.
But in spite of that,
He continued.
he disbursed loan.
Yes, his birth loan, and the thing is that, my lord, he disbursed the loan in the tune of 100, around 102 lakhs. And my lord, he is saying that 86 lakhs has been recovered, and that is recovered by the bank authority with the endeavor. That does not extinguish his fault.
No,
Whatever amount has been recovered by the authority with applying their power, and that is their capacity. But yes, my lord.
what was the amount recovered?
My lord, what he has stated, exact figure, I don't have any information at this at present. But what he has places in this appeal, that is 86 lakhs. My lord, remaining part, he is silent. My lord, that is public money, my lord. He cannot do all these things.
No, very good. Now, please answer our
Yes.
question. If the sanctioning power was not there on and from 20th of October 2005, then what is your reply as regards the loans which were sanctioned prior there? What is your stand?
My lord, I think there is other letter also before that. My lord, kindly come to page 331 again, my lord. Again, you are instructed. That means there are previous instruction. Again, you are instructed means there are other instructions also previous to that not to disburse the loan.
Have you stated?
We should not use the word again.
So very good.
Yes.
Show us any such letter. That was not.
At present, I don't have. If your lordship direct, I will bring
What
from my.
is your stand in the affidavit in opposition? You must have said
Yes,
that.
yes, my lord,
First paragraph.
yes.
Hmm. Your affidavit in opposition.
Yes, my lord,
starts
my lord,
from
yes, my lord,
38.
yes.
No, sorry. Your affidavit in opposition is which page, Mr. Pal?
It is started 287.
287.
Part 2. Yes, my lord, paragraph 16. I have stated 295.
Just.
Paragraph 16 of my affidavit in opposition.
That. Para 16.
Of my affidavit in opposition, page 295.
Yes, what you have said.
Yes, my lord, I have said the regional office of the bank vide letter number such and such dated what I have submitted just now.
Just now. What?
Yes, the middle of that paragraph dated 2010-2005 and letter number such and such 1/12/2000 advise the writ petitioner not to sanction any loan without any further clearance from this office, their office. It is relevant to mention that annexure P4, which is referring the letter dated 18/6 was issued in continuation with this letter.
18th, not 18th March.
18/3/2006. Now, what he has placed that
Want to ascertain whether any letter was given prior to 20th October 2005.
my lord, that I have to
Justify the use of word again.
again. Yes,
And
yes.
hence take
Yes.
us to Yes, to 295.
Yes.
You lost the.
Yes, yes. Actually, the thing is that at present I have no such document and no such instruction to this. If your lordship direct me, I will have the instruction from the client.
That we cannot do now because we have to decide on the basis of the records which are there.
Yes.
Yes, that apart, that letter was placed before the inquiry officer or not. Suddenly you come up with a letter.
No, not
It
that.
is a proceeding.
Yes, obviously.
Whether you are placed before the inquiry officer or
So,
not.
my lord, each and every document has been placed before, and he has given ample opportunity. He appeared, and my lord, he has stated that some irregularity he has made without his knowledge or something like that, and he has replied to that charges, my lord. All the opportunity has been given. He participated. He never agitated before that. Before the appellate authority, that inquiry has not been done proper way. He has
Yes,
been
yes,
deprived.
he has said that. Appellate authority, he has said that.
Yeah.
Inquiry has not been properly done.
My lord, it is stereotype thing. It's
No, whatever.
yes,
You show us we are asking you, Mr. Pal,
yes,
that you have shown us 20th October 2000.
yes,
You are saying that the again word suggests that
yes,
there were previous.
yes.
Have you said this in your inquiry before the inquiring authority?
No, my lord, inquiry, actually the thing is that the problem is that
All right,
this
what is
this
your
this
next
this,
submission?
this affidavit in opposition made by the Canara Bank Authority, and my lord, everything, all the proceeding has been completed before amalgamation, and that has been done by the then
Your-
syndicate bank.
What is your next contention? Anything else you want to show?
Yeah, my lord, that my contention is that, and my lord, I'm coming to my affidavit in opposition also. Again, I'm regarding the non-existence of. Yes, paragraph 19, my lord.
That you have already placed.
Yes, my lord, the Bolai, he has sanctioned loan to Sri Bolai Ghosh on 16/6/2005. The said Bolai Ghosh was the employee of a jewelry shop of Mr. Brindavan Ghosh and staying with him. He did not have any independent business. My lord, he has sanctioned loan. And my lord, have no credit worthiness. And next is Srimati Putul Ghosh, to whom working capital limit rupees 5 lakhs was sanctioned, who has no business activity nor any credit worthiness.
Yes.
My lord, this I have stated. Taking all this, what he has referred, my lord, already I have taken in my affidavit in opposition. My lord, my submission is that whatever I am just summing up, my lord, whatever sanction of loan he has done, that is after withdrawing his sanctioning power of loan. And in spite of sending repeated letter from the head office to him, he continued to sanction the loan, and he has sanctioned the loan to such an authority who is not at all existing. And another thing is that that amount of 102 lakhs, near about 102 lakhs has been sanctioned. And my lord, out of that, with the endeavor of the bank authority, subsequently, he has no credit for recovering 86 lakhs. My lord, by this time he has transferred. My lord, after his transfer with the credit of the bank authority, some portion of that loan has been recovered. And my lord, that doesn't extinguish his fault, my lord. And he has defaulted the public money. And my lord, after giving ample opportunity and every scope to represent before the inquiry officer and the appellate authority.
Show us your rules, Mr. Pal.
Yes.
Your disciplinary and appeal rules are there.
Yes, my lord. My lord, that has been annexed.
Yes.
(308) onwards of my affidavit in opposition.
P08.
That is the rules of the then syndicate bank. Not,
Yes,
yes.
All right. Anything else, Mr. Pal?
Nothing, my lord.
Thank you. Yes. Yes,
My lord,
show us the letter by which.
my lord, at first I have something. My lord,
First, show us the letter.
page 80 of a paper book number 1.
Page 80.
Page 80.
Hmm.
Second July 2009.
What is this? This is the punishment order.
Lordship, not punishment. Sanction.
Reply was.
No, Lordship, there is forfeiture of this provident fund amount.
Where is that?
Kindly see this. The sanction credit facilities such and such withdrawn the sanctions of the regional office omitted irregularities and details of the total. The both of activities are possible. So it should protect in this bank interest and have honesty deviation etc. In becoming.
You have done subsequently.
Subsequently, Lordship, they are
Imposition of punishment.
Lordship. No, Lordship, there is a forfeiture of this provident fund amount.
No, this is the second show cause notice. By this, you were asked to reply. This is the proposed punishment.
Lordship, they are
Read the last paragraph.
last paragraph. They are the proposed punishment. The proposed punishment is
So
that.
why you are showing us that? We are asking you the letter by which your provident fund has been stopped.
This letter, Lordship, page 81. Let's kindly see.
Page 81 is the proposed punishment.
Lordship, kindly see the last paragraph. Now, therefore, you are called upon the show cause. Why, as to why the rupees such and such or 1,000 had been payable to this management contributions not be forfeited. Not be forfeited in terms of this regulation 19A of the Provident Fund towards the financial loss sustained by this bank. The forfeited. The Provident Fund amount are also forfeited. Future employment are also rejected. And Lordship, my learned is submitting that the 20 October.
Show us the final punishment. Final punishment is dismissal from service.
Lordship.
Final punishment is date হচ্ছে 9
And
2008 আর এটা হচ্ছে 2009
সে তো হবেই 2
নয়
19th of August 2008 হচ্ছে punishment.
My lord.
Dismissed from service. Oh.
And 30 December 2008, that is the appellate authority's order of this appellate authority.
After that, this was issued.
30 December, after that. After that, forfeited. My learned friend submitting before your lordship that stop this loan after getting this letter 20 October 2005.
So, did you challenge this forfeiture of provident fund?
Letter.
What has been done after this? You gave a reply to it.
Lordship, let's say page 82.
Yes.
80.
Now, what did they do thereafter?
There is no reply at all. They are remain silent. No answer.
Did you challenge this memo in the writ petition? This forfeiture?
Forfeiture, Lordship, I am challenged.
You have challenged?
Lordship. Along with this writ petition, it also annexed. Kindly see, Lordship, within the
order of forfeiture.
80.
This is the show cause you have given. 62 lakhs, 6 lakhs, 20,732.
32.
That was the management contribution of Provident Fund.
My lord.
And your own contribution you have obtained.
Lordship.
You
They
obtained
are
your,
released. Your contribution already released.
where do we get that?
Employees contribution release. They are adjusted with this the home loan. They are also the home loan, not this given the check, not payment by cash.
So you had a home loan.
Home loan.
So where is that letter?
No, that letter are not annexed.
So
Employees contribution already adjusted with the home loan.
employees contribution at,
But he also 29 years.
so you are not a pensioner. Under your scheme, you
No.
have no pension.
I am retired on the 31st December 2018. 31st December 2018. I am retired from service. But intentionally they are delayed, not file any opposition, etc., etc.
Then what does the rule provide for forfeiture of the contribution?
As per rule.
Huh?
As per rule 19A.
Where is that rule?
19A. She kindly see a rule rule.
Rule he placed, that is page 308. Show us that provision.
19A আমার কাছে নেই আছে 19A দেন
এটা তো ঠিক
পেজটা ওখানে নেই 19A কোথায় এর মধ্যে নেই
না, যেহেতু gross negligence তোমায় ডিসমিস করেছি। রুল 19A, page 308.
রিভিউ
Rule 19.
16 17 18 19
19, it is not there, Mr.
There is no such A.
no such provision. Seventeen, 18, 19. The 19 is the contributions with the Central Vigilance Commission.
Page.
No, not here, but the rules are separate rules. The syndicate plans, officers, employee regulation, 1976. That's separate. Separate.
This is
My learned field also annexed. The syndicate bans, officers, regulation, discipline and appeal, 1976. Along with this,
that is page 309.
Lordship.
But what is that rule? Show us.
That rules, in that rules, within the rules, there is not available.
And
19.
কি রুলস দিচ্ছেন
Syndicate ban, officers regulation.
তাহলে সেটা তো এখানে থাকবে।
Regulation. You are showing us this is already annexed.
Already annexed.
Then what regulation you are showing related to forfeiture?
Retirement benefit scheme or rules or pension regulation, bank pension regulation, most probably.
They are mentioned in this letter that forfeited at per the rules, in terms of the rules 19 sub-rule A of the provident fund towards the provident fund.
Where you are reading?
The page 81.
As per rule 19A of provident fund towards financial, where is this rule?
The provident fund, that is not clearly hot rules. The provident fund, only the provident fund. All are ambiguous.
No, Mr. Pal, there is a rule for forfeiture of PF.
Yes, my lord, my lord, at present, I don't have that thing, my lord. Actually, the thing is that everything has been done before amalgamation. And now all the burden has been shifted to the Canada Bank. And my lord, we are stepping on the shoes of a syndicate bank without doing any mistake.
All liabilities goes to Canada Bank.
What is the,
Defend their justified action, but don't
Yes.
defend their unjustified.
No, obviously not. But I am not getting any such of provision in the, and my lord, if your lordships have.
page 81, it refers to rule 19 within bracket A of the provident fund towards financial loss sustained by bank.
Yes,
What rule?
What is this rule 19A?
What is the rule? The regulation of the officer's employee.
My lord.
In the officers entry regulation, there is 19, there is no provision at all.
My lord, at present, I am unable to answer, my lord. Actually, I have not gone through this, what he has referred here, and that has been done by the then syndicate bank. My lord, at present, I am not in a position to satisfy your lordship, my lord.
Judgment.
My lord, I am
এখানে কিন্তু দেখুন বেনিফিট সম্বন্ধে কিছু বলছে
Conduct rules. সাধারণত থাকবে।
Your lordship can fix a date directly. I will inform my client to provide all this to satisfy your lordship regarding this query, and also regarding the letter which I have already submitted, that previous to that 2005 any other letter was issued or not. My lord, subject to your lordship kind permission, I may satisfy, my lord.
my lord, my respectful submission before your lordship. Lordship submitting, showing the documents on 20 October 2005. Prior to 20 October 2005, 91 lakhs amount already sanctioned, and there is 5,33,300 in the agricultural loan, and there the agriculture allied business loan on the 11 lakhs. And lordship knows very well, as per the agriculture waiver of this loan 2008, RBI already announced, and within the purview of waiver of agricultural and allied loans 2008, all these 5,33,300 and 11 lakhs 91,000, all these loans are recovered, and 91 lakhs also disbursed prior to the 20 October 2005. My land, but
My lord,
the second loan,
due our attention to the letter dated 20th October.
lordship.
yes,
Kindly see the 91.
5 now you are saying.
yes, my lord, he has joined in the bank.
91 lakhs, kindly see lordship, 91,
Yes.
91 lakhs.
We have differentiated 91 loads prior to 20 October or
2005.
October, and the next second page,
Agriculture.
second page,
The
5 lakhs and odds.
33,300. And 11 lakhs. 11 lakhs
These loans were given after 20th October.
after
2005.
21. But lordships, the disbursing of this loan, not a break of a car. The process, some application are submitted.
It's appearing for the respective parties. Stop.
That's very
Records reveal that the petitioner was dismissed by an order dated 19th of August 2008. The statutory appeal preferred against the same was also dismissed by an order dated 13th of December 2008. Stop. In course of hearing, it has been pointed out that subsequent to issuance of the order of the appellate authority, a memo dated 2nd of July 2009 was issued asking the petitioner to show cause as to why a sum of rupees 6,20,732 payable as management contribution of provident fund should not be forfeited in terms of এখানে আছে page 81 এ পেয়ে যাবে, হ্যাঁ, in terms of rule number 19 bracket A of the provident fund towards financial loss sustained by the bank. Stop. Mr. Pal, learned advocate appearing for the bank, had not been able to place before us the relevant rules. Second shukase for recovery of such and such. তাই তো বলেছো? Mr. Bishya submits Mr. Bishna, tarpore Mr. Pal. Mr. Bishas learned advocate appearing for the petitioner submits that the said amount of rupees 6,20,732 has been forfeited. Stop. তারপর মিস্টার পালের ব্যাপারটা কি লিখেছি? মিস্টার পাল relevant rules on the basis of which
My lord, time may be given to me to satisfy your lord. Yes.
Mr. Pal has not been able to. Stop. Next, Mr. Pal stop. In view thereof, this court directs the bank to place before this court
Yes.
the rules, the relevant rules in terms of which the show cause notice dated 2nd of July 2009
Yes.
at page 80 of the paper book was issued. Stop. Mr. Bishas, Mr. Pal is also not dismissal.
My lord, regarding the letter, I also may get chance to produce before your lordship for the sake of justice, my lord.
Bring it that we will.
Yes, my lord.
consider.
Yes, my lord. If there is any.
Please the matter for her. Please the matter for further
How
consideration.
many witnesses were examined by the management?
My lord,
2 witnesses. And how many documents they were admitted in evidence?
evidence the
300 documents.
384
Documents.
exhibit 384 exhibits. They're the ambiguous. They are the but this without investigations. The investigating officer submitted and placed all this information before this inquiry forum as well as the disciplinary.
384 documents by 2 witnesses.
Penalized, highly penalized. Lordship, kindly see the two judgment. Kindly see the judgment of the Supreme.
17th
When
October.
we shall consider the
17th October.
principal let down in the judgment, then we shall, Allah.
Yes. 17th October,
17th October.
you place before us the relevant rules on the basis of which you have
Just,
forfeited that.
just before puja.
Yes.
My lord, make it after puja.
No.
My lord, the thing is that,
Not
my lord, the thing
no.
is that the branch
I-
from.
Then we keep
my-
it
my-
on,
just-
then we
objection.
keep it on 10th of October. 10th of October will be better. Please.
No, my lord, in that case, my lord, 17th October is all right. My lord, actually, the thing is that it is of Murshidabad. I have to bring the information.
Ask your officer to
Yes,
come.
obviously.
Is the relevant officer, he should be present in court.
My lord,
They do not bother you to give you instruction.
no, not.
After hearing the matter, substantially, we were delivering the
Yes.
judgment. You said this rule is not with me.
I'm grateful to Lord.
Not, it never.
And if he doesn't come, we direct the personal appearance of your officer.
No, my lord, no, my lord.
Tell us who is the officer.
No, my lord, it is not required, my lord. The document
Mr.
will.
Pal,
they will-
kindly-
Yes, my lord,
It's a
kindly
long
appreciate my proposition also.
Upon appreciation, we have given you 2 weeks.
Yes,
time.
my lord. Man, 17th October, my lord.
Yes,
I'm
next.
grateful to
Much
Lord.
Which judgment you are relying?
Lordship, the judgment.
That judgment only. Technicality.
See judgment, color.
Misconduct.
Lordship, kindly see the judgment. The
We will
paragraph,
see the judgment.
paragraph
Give us the
26.
citation.
I am.
My lord, there are several judgments where it has been stated, if there is no violation of natural justice.
All right.
All right.
Yes.
My lord, I will place also, next date of hearing.
So on the next date, we shall take.
Lordship, please have the judgment. I am placing the paragraph number 26 and
Just give us
আরেকবার দেখে নি 234
আরে শিওর হয়ে তারপর দিন।
Yes.
Yes.
Who is the petitioner?
আমি দিয়ে দিচ্ছি
You are for the petitioner?
I beg to
Yes. What is your matter?
my lord 15 years aged girl my lord kidnapped my lord by the respondent number 8 my lord several representation
Have you served
my lord
state service?
I have my lord service but my lord the as per the track report my lord service shows that the death watch, not my lord the confirm but my lord the as per this my lord 15 years aged but my lord the Pingla police station informed the petitioner that the voice record all or my lord the he is concerned my lord I have my lord annex before your lordships page 30 and 31
What?
in the petition my lord 30 and 31 my lord.
Yes, what is this?
My lord, this it is a SMS, my lord, this WhatsApp chatting. The Pingla police officer, my lord, sent my lord the all the voice record of the victim girl who, my lord, see who is my lord the kidnapped. But my lord, but he is completely not my lord cause any needful for produce. Because he knows that my lord, he knows that very much where this my lord the girl has been kidnapped and where and whose custody he has been my lord this but my lord in spite of
My lord, this is a case where, my lord, on 18th July 2023, the petitioner's daughter went to her maternal uncle's house at Sikkim, and he is missing from Sikkim, and one FIR has been lodged at under the state of Sikkim at Namchi police station, my lord. Kindly see for a moment. Paragraph number 4, it was stated by the petitioner. And thereafter, my lord, kindly see paragraph number 9.
So how does that help you? You have registered a fresh case on 28th July.
One representation was sent to the police station, my
Very
lord,
good.
through superintendent of police.
Who is the accused here?
On
The 28th July?
my respondent number 8 my lord.
Wait,
respondent number 8, my lord.
so why you have not interrogated
No,
him?
we have already started inquiry, my lord.
Inquiry, have you
investi-
apprehended him or he is escaping?
My lord, on 25th August, one representation was received by the police through the superintendent of police. My lord, thereafter, police contacted with the Sikkim Namchi police station, and raid was conducted at Bhubaneswar, his uncle's house, my lord. Thereafter, police went to Kotok in his sister's house. My lord, investigation is going on, my lord. But in this case, petitioner was the missing girl was missing from Sikkim.
No my lord
No,
may I sir
respondent number 8 is not of Sikkim.
My lord.
He is beside your police station.
Yes, my lord.
So why you have not taken steps? He
We
is
have
the
already
principal
we have already taken steps, my
So
lord.
did you call him in the police station? This person, did you call him?
Yes, my lord.
Called him?
41A notice was served to his address, but he has not turned up,
Then
my lord.
41A violated, why you are not arresting him?
Thereafter, police went to his house and he fled
When
away. My
did
lord,
he-
case has been lodged on 25th August only,
No, it is 28th July.
my lord. Next day, my lord, if your lordship kindly allow me, then next day I will produce the report of investigation.
Your police contacted with the Namchi police or not?
Yes, my lord.
So what is the result?
And on requisition,
Yes.
police went to Bhubaneswar as per the request of Namchi police station. Thereafter, after conducting raid on that date, my lord, in morning, they fled away. Both of them are fled away from Bhubaneswar, yes. Now case is under investigation, my lord. Kindly allow us some time, and next day I will produce the report of investigation.
my lord, several books recorder, my lord, which, my lord,
Now
is not made.
not in Sikkim.
No, my lord. Sikkim police station, my lord, through the track report, intimated that, my lord, the victim girl is in West Bengal. And my lord, what happened? The respondent number 8, the accused person, is a, my lord, the relative of a Panchayat Pradhan. So that is the main problem, my lord. Several times, my lord, no complaint has been registered. That is why I have to, my lord, intimated through speed post, my lord. Superintendent of Police of the Paschim Medinipur. My lord, kindly, my lord, this voice record, my lord, kindly, if your lordships. So all the voice record I have sent. My daughter's, my lord, conversant under pressure. That is the voice record. And he knows that the Howrah, sometime she is, my lord, kept in the Howrah. See, my lord,
Whose voice record? The victim girl?
Victim girl, my lord, called the petitioner one time.
Yes. When did he call?
My lord, did call, my lord, I have 7 days ago, my lord. Kindly,
Then
my
what did she say? What did she
She
say?
says, my lord, may I just start, if you lordships allow me?
Not starting. You have heard it.
That
You
is
tell us.
that, my lord, the I have, my lord, came with, my lord, this name, that's respondent number 8, my lord, and I am well. But, my lord, when this, my lord, the petitioner says,
Says I am well with respondent.
I am well with, but under pressure, when the petitioner, my lord, says where he is residing, see, my lord, completely another voice is, my lord, just whispering, he is completely silent. That is the main thing.
Police has already.
My lord, birth certificate has been manipulated. I have annexed.
Take this person.
My lord, police has already engaged a good number of sources, my lord.
41
As per my belief.
You are sleeping.
My lord, thereafter, police went his house for arresting him, my lord.
Then?
But he fled away. My lord, kindly give us some time. I hope he will be recovered, my lord.
My lord, when the police.
Where is the, if any case was registered?
Yes, my lord. At
363, 364.
363 case was registered under section
Prescribed
363.
punishment,
363.
10 years.
And my lord, POCSO also we.
They are giving for 41 years.
My lord. As per verbal instruction, my lord, I have submitted before your lordship.
So then he is a very good friend of the Panchayat Pradhan, maybe.
So that is his submission, my
So
lord.
when the police in a 10 years punishment issues 41 a notice.
No, my lord, that is on verbal instruction I am
POCSO
submitting before your lordship. It should not be.
Kindly ascertain the submissions. You should have taken it up with your police officer. How could you have said that, sir, we are searching out, we have given 41A, he will come to us. 10 years punishment, 41A. That means you are linked with the Panchayat Pradhan. Your concerned officer is linked with the Panchayat.
No, my lord, they are trying to find out the girl, my lord. Kindly allow us some time, my lord. I will produce
What is
the
the
case.
name? Where have you stated? Panchayat Pradhan?
My lord, this is, my lord, when, my lord, this petitioner.
Who was the
my lord, kindly, my lord, kindly, my lord,
who was the abandonment
may I submit?
first? Who was the
No, may I submit, my lord? When I, my lord, just consented to the petitioner, just to, my lord, canvass the averment, she, my lord, stated that, my lord, she is to reside on that place. So if he, my lord, disclose the Panchayat Pradhan's name, my lord, she will not be, she completely driven out from this area. That is she is fine, my lord. My lord?
You are making an allegation that person is a relative of the Panchayat.
My lord, it is.
You have not said that in the petition.
Because
now you are explaining such latches.
My lord, because, my lord, if I, my lord, explain, my lord, she apprehended that if, my lord, this has been disclosed, she will be driven out, my lord, driven out from the area.
He understood. We are keeping it on Tuesday. We want your developer. In the meantime, what happens to this respondent number?
My lord.
Dear.
And Mr. Chatterjee, learned advocate. Mr. Chatterjee. Or maybe next time. Release this matter for further consideration on 28th September.
পুলিশ 41 নোটিশ দিয়েছে 41 নোটিশ তো হবে না কিন্তু ম্যাজিস্ট্রেট লেভেল কেসে হয় 07
As regards the chapters of the
on the returnable stage এই বলেছে কি ওটা কি ঠিক আছে
as regards status.
বলে দেবে দুই বার তুমি ভাববে কেন তুই সাথে সাথে ফোন করে দেবে কালকেই আজকে রিসিভ করছি আমি তো তোমার পার্টি ওটা ফটোগ্রাফ
ও আমি
তোমার যে কারেকশনটা তো এগুলোর উপর রিলাই করতে পারো এই তোমার তারপর তোমার যাতে কথাটা বলতে Yes, great.
Yes, please come with a report.
My lord. See, Mr. Chatterjee,
My lord, I will try, my lord.
get hold of him.
Milord Pinaki only in this matter.
My lord, I am for the appellant, my lord.
Milord Pinaki only in this matter. He was there, all along he was there. Just 15 minutes back, he has gone to the court number 5. Kindly crying for not today, man. Praying for not today.
So he left at the best time.
Just 15 minutes back.
What happened? You have filed your opposition?
Yes,
lord.
file of opposition.
My lord, they have filed opposition and we have also filing our reply to that opposition, my lord.
What delay of how many days?
1977,
1977 days. my lord.
1977,
1977.
6 years.
1977. আর কি হলো তার?
My lord, our reply may kindly be,
আচ্ছা সে what is the main writ petition, sir?
so
Yes, place the main writ petition.
what happens, my lord, subject in nutshell is that the petitioner before your lordship was appointed on contractual basis on 1st July 2010 for 6 months under the concerned respondents, and subsequently by order dated 29th May 2017, service of your petitioner was ended with effect from 31st March 2017, and the service of your petitioner was not considered for renewal and was terminated with effect from 1st April 2017. This is the story behind. So, my lord, the petitioner before your lordship was an unemployed youth, my lord, and my lord, subsequently, that writ petition was heard at length by this Honorable High Court, my lord, and that writ petition was dismissed. Challenging this writ petition, the appeal was filed, and subsequently that particular appeal suffers from 1977 days delay. And this particular question arose from the end of the concerned respondents, and that is why, my lord, they have filed one reply in respect of our section 5 application. And we have also filed today, we are filing also the affidavit in reply in respect of their affidavit of opposition in connection with section 5. So, my lord, my respectful submission has been canvassed in page number, paragraph number 8, page number 6 to 7. My lord, that is my whole submission, and a very candid submission before your lordships.
They have shown the delay that only for the COVID period. They have shown the cause that they are late
for the COVID.
What is your, how do you succeed? Tell us what is the wrong in the order?
Similar,
Your contractual engagement was till 2017 May.
my lord, I am,
2017 March.
my lord, kindly appreciate, my lord, today I am only concerned about the section 5 application.
No, no, we will allow section 5. On the merits of the matter, you tell us.
My
On
lord,
the merits of the case, you tell us.
my lord, kindly fix at least a day. My lord, I will place before with my learned senior, my lord, Mr. Jana. I will say, I will place before this case before you lost. My lord. Well, 7 days, only 7 days.
Your senior.
Snehashish Jana.
Yes, we are here. You tell us what is the wrong in the order. 2017 order, contractual engagement terminated.
I understand.
Allegation was against, good allegations were there. It is the absolute discretion of the state whether
That
they
is,
will
my lord,
conduct.
absolutely, my lord. That is absolutely, there is no denying of that, my lord.
Tahole
There is no
again,
denying of that. I do not have any right.
Come with a better case, sir. Come with a better case next.
At least my delay may kindly be condoned, my lord. At least.
We will condone the delay,
My
but
lord.
what is your contention on merit?
It is admitted that I do not have any right, but I was engaged and subsequently I was terminated. Thereafter, I made representation. That representation was not considered by the concerned respondents, my lord.
Where is the writ petition?
Writ petition, my lord. Yes, my lord.
Give it to us. You are junior to say.
Huh. Not today, then tomorrow. Delay may kindly be condoned, my lord.
আরে কন্ডন করে দেবো
My lord, my lord.
Operation successful, patient died. Limitation allowed, main petition dismissed. Come with your writ petition and what you want to show us.
My lord.
Yes, next. Not today, Kula. ও শেষ বেলায় ঘুরতে গেল 50
ছোট আমরা শুধু।
When you said Chotto Mamla, he started laughing.
Because he knows I am right. Lord, I am the West Bengal Zoo Authority. Now, my lord, I have transferred the writ petitioner from Alipur Zoo to, there is a new zoo which has been set up.
One submission before Mr. Dotto makes submissions on merits of the case. Well, in my most respectful submission before your lordship, well, this appeal has now become infructuous.
Can we?
Why do
Because
you
I
say
tell your
so?
lordship why. This appeal was against a limited interim order. That after the during the pendency of the limited interim order, and the interim order was extended by another order. The second order extending the limited interim order is not under challenge. There is a reference made to a larger bench regarding this issue alone, that whether another appeal would lie when a limited
been
interim-
extended.
Yes, I will place that judgment before your lordship. Kindly take the issue which has been formulated by the revision bench.
What is that?
What did the court say? That there has to be a
Second, another appeal.
two appeals have to be there.
But the first appeal has practically become infructuous. Well, may I just hand up, Madam?
No, it was an order of transfer.
No, it's an interlocutory appeal.
No, I am saying that subject matter in
Here,
It's
here
order
it
of
is
transfer.
transferred.
Order of transfer.
order of transfer.
Right.
Now he has been transferred or
No.
interim order is protecting.
Interim order is protecting him.
That ultimately expired during pendency of this appeal.
And my lord, when it is before the expiry, my lord, the interim order was extended by the learned single judge. We have the orders. And the time to file affidavit in opposition was also extended. This is the order which was passed extending the interim order.
Mr. Dotto, then check it up and come.
Milord, so far as this is concerned, Milord, I have no quarrel with this proposition or that it has been sent to the larger bench for adjudication. But Milord, principally, Milord, the appeal doesn't become infructuous. Appeal remains. Whether your lordships would consider it to be an academic exercise or not, that is something different. Because appeal, as your lordships know, Milord, is a vested right. The day
But Mr. Dotto, you have to come up with the other part of the order, na? So we are not dismissing it. You file an appropriate appeal. Then we will hear your submission with, because then it becomes immaterial. You will be arguing on the merits of the. But has it expired? Interim order has expired.
Yes, yes.
No. It has been extended, madam.
extended one is continuing.
Yes.
Extended one is continuing, no doubt about that.
Then Mr. Dotto, why you are aggrieved? Why? Oh, you are the authority.
Yes, madam.
I am the authority. The principal order, the primary order is affecting me. It is only an extension. Extension, as your lordships know, Milord, is only expanding the period.
So if Mr. Mojumdar takes that point, what can be done? We can do this much, we can keep this appeal pending. And if you file a fresh appeal and come with a notice memo,
The
we shall
matters can be
include it.
Very well.
Both the matters.
Milord, in that case, kindly, Milord, keep it on Tuesday or Wednesday. In the meantime, Milord, I'll try to file it, Milord, in course of this week. Today we are on Wednesday. I'll file it within Friday. We'll come and take your lordship's leave, Milord, to file with without such a.
Mr. Dotto, what we do, we send it out of list and you mention it before us, we will enlist both the appeals together. That
May
we can
I
take.
only make this prayer, Milord? I know, Milord, dear lordships.
So we are, the thing is, if it goes in the combined monthly list, October, then it will go a bit down in the disease.
But I was praying this, kindly keep it, Milord, sometimes next week. Monday or Tuesday, subject to the convenience.
There will be no problem, Mr. Dotto. Once your junior mentions, we will give both the appeals in the list.
After a lot of trouble, Milord, we could get this matter listed
No,
today.
this we can say because this is the practice we have followed. There will, hopefully there will be no problem.
Very well, Milord, I'll come back on Monday and mention. To remind your lordships, Milord, and in the meantime, I'll ensure that the appeal is filed, because no use, Milord, going into all these questions. Because I need an order from the appeal court. We're digressing from the main thing, Milord. I don't think, Milord, there is any use of going into all these legal aspects.
There are no other parties, na? You are appearing for.
Milords, may kindly consider, Milord, simply adjourning it, Milord. In the meantime, I'll take steps.
Adjourn to which date?
Maybe, Milord, on Tuesday, subject to your lordship's kind consideration.
We do this thing, we will keep it in the.
On a Thursday week, my lord, Thursday week.
We are keeping it in the combined list of October.
Very well.
Once he files the appeal, he mentions.
Well, I'll come back, Milord, this month itself. Milord. Kindly don't keep it in the monthly list.
এই মাসে কবে আর হবে? একটা সপ্তাহ।
আজকে তো 20 তারিখ।
ছুটি নেই মধ্যে?
Well, that will be subject to your discretion of your lordship.
Well, please keep it on Thursday, Milord. In the meantime, I'm taking steps, Milord.
Thursday week.
Thursday week.
Very
ঠিক আছে।
I'm grateful, Milord.
হ্যাঁ, নিশ্চয়ই দেখে নাও। দেখো ফাইলে রেখে দিও, এটা থার্সডে উইকের আগে পাঠিয়ে দিই, আগের দিন পাঠিয়ে দিই। হ্যাঁ,
নাহলে একটা জেরক্স করে লিখে দেবেন আর একটা আমাকে দেবেন।
হ্যাঁ, নাও না। আজকে কি ডাকার আছে?
অ্যাপিল মানে হচ্ছে না, সেক্ষেত্রে তাকে এক্সটেন্ড হবে, সেক্ষেত্রে অ্যাপিলের পর অ্যাপিল হয়।
ডিভিশন বেঞ্চ বলে ফেলেছে না, কিছু নিশ্চয়ই বলেছে তার পেছনে।
কিছু নিশ্চয়ই আছে, দেখতে হবে বিষয়।
দেখুন কত থেকে আসবে?
Your Lordship, I'm appearing for the appellant.
Hmm.
Your Lordship, this application is arising out of Order 21, Rule 101 of CPC. Your Lordship, by mistake, this matter is appearing here. It ought to be appearing before this Order 41, Rule 11.
Item number 204.
My lord,
এই ফাইলটা দাও একটু।
this appeal arises out of an application or order 21 rule 101 rejection.
This is an appeal arising.
Order 21 rule,
Rule 101.
it is an appeal under 103.
This is appeal. Not to be admitted under order 41 and then
Mr. Kindly give your copy. দেখি।
there was an eviction decree which we have executed. Thereafter, an application was done and that was executed.
This is a first appeal.
This is this would
Second
be
appeal.
registered first miscellaneous appeal. It would be,
Not required to be admitted.
my lord,
Required admission.
it requires admission.
So where you have mentioned that order 21 rule 101 order?
My lord, you see the certified copy is annexed.
The present appeal is arising out of an order. First under order 21, rule 101 of the code. And it's connected as stand stand.
Yes, next one.
Grateful lordship.
I beg to appear for the appellant.
What are the applications?
My lord, applications, my lord, against my lord the recruitment of the Bangla Shohayata Kendra.
No, no, can one, can.
Oh, can one, my lord, this is application was stay, my lord, stay.
Application for stay.
My lord.
And can two?
My lord, one is my lord for application for condonation of delay, and another my lord is for stay.
For stay.
My lord.
So condonation delay allowed?
My lord, as per the last order, my lord.
Affidavits were directed.
My lord.
Affidavits exchanged.
My lord, affidavit exchange.
Eh?
My lord, affidavit has been exchanged, my lord, but the report, my lord, the report has been, my lord, directed to submit it. But my lord, may I submit the report, my lord, first? Which
You are
is
for
not.
the state.
No, I am the appellant, my lord. I have been served, advancedly served, my lord.
Report on affidavit has been filed.
But my lord, I have, my lord, served only a report without any affidavit. only a report. Well, the inviting the applications for online application, and after
Have you taken any exception to the affidavit?
my lord, I have submitted the exception, and after exception, my lord, the honorable my lord, the erstwhile my lord, the bench my lord, directed to submit a report for each and every candidates my lord, the
By which
unique
order?
last order. It is the last date my lord. I have. My lord, 15th of May 2023.
Have you taken inspection?
My lord,
Was
I have taken inspection. My lord, there are several my lord, the inconsistency my lord.
When was the selection done?
Selection done my lord, this 2021 my lord.
Anything remains? Did you get any interim order? Any post was kept vacant?
My lord, I have been given my lord the without my lord showing the unique identification number.
We
My lord,
understand.
they
Now
have
the posts
published only for the
have
merit
been
list,
filled up.
Aadhaar card.
Posts have been filled up.
Post has been filled up, but my lord, several another post my lord is vacant. That is my lord the
That is not in relation to
total,
this selection.
not my lord, total post has not been filled up. Total post has not been filled up.
Posts have not been filled up.
No, fully not fully filled up, my lord.
Who is your other side? Who appears for Weber?
My
and
lord,
Stern?
my learned senior minister, my lord, the Urunabo Ghosh, my lord, he is appearing for the Oevel.
My lord, I have
And
been
for-
requested to pray for adjournment. Mr. Nabago is appearing. Could not come today.
And another the from state, my lord, the
Bishop
Sayon
Weber.
Ganguly. Yes.
Come back next day, let us see. Not today. Together for it.
Not to the order.
কত ডাকি? 1000. 206 বের হয়ে গেছে। 207 টা ডেকে দাও। What is there? You are for the appellant? Who is for the respondent?
Respondents are, my lord, intentionally avoiding, my lord. I'd say
What is the application for?
this is, my lord, application for stay.
All right, we take it up.
And my lord, difficulties, let me, my lord, submit one thing that
This will be the first
in
matter.
September 2022, they were directed to file an opposition to my application. ultimately sometimes before the summer vacation, there was a peremptory direction upon them to file opposition to the application. But till date, neither they are appearing. There is no question of filing opposition. So this thing is going on.
Hear it on the next day. It will be the first matter.
My lord, grateful.
And in the meantime, you may give a notice to the person who entered appearance.
My lord, I shall. Shonchita Bormon Roy, I believe.
Whoever is it, come
My lord,
with that notice to us.
my lord.
Take it up to them. না তিনটে সুগত শাসন রেখেছি কেন
My lord, under the compelling circumstances, I am seeking leave to file one review applications in respect of the determination of the
Our
determination of court number 12, Justice Division
leave
Bench.
of Mr. Justice Mojumdar and then mention.
With the leave of Justice Majumdar, I am seeking. It says
Why you are mentioning?
recalling application review application which has to be filed. Review application by a government officer, lordship, against whom a
So
direction
what
for
do you want?
leave to file without certified copy.
Review cannot be done without certified copy. Rules diverse. You have to obtain it.
The only thing is that
Try your send your clerk with the certified copy, immediate requisition will be made. There is no problem with it, but you will, this
but
will
we
be a
made
problem.
the application.
You send him sergeant certified copy, you will get. Immediately you file before us. Yes, call the list.
Yes, my lord, I am appearing for the appealant. My lord, so far, these two appellant is concerned, two appellants is concerned, Lodhai.
Kurban and Lodhai.
Yes, my lord, Kurban Ali Mundal and my lord Lodhai. My lord, against these two, my lord, first Kurban Ali Mundal, there is only confessional statement. No witnesses, nothing recovered, nothing placed on, my lord, no identification, nothing, my lord, no way connected with this, only 164 statement, my lord, he has been convicted, and not only that, more than 24 years, na? Today, 20 years, he is languishing in jail. He retracted his confessional statement when during my lord 313, when because my lord his personal lawyer not appearing, legal aid lawyer is appearing, he could not, perhaps my lord, he could not, my lord, ventilate the agitation, my lord, before the learned trial judge. When he, my lord, given opportunity of 313, he, my lord, retracted the 164 statement, and how he manner he my lord, retracted, kindly go through page, my lord, 330 page gulo. Against criminality, nothing, only 164 statement.
The page 599.
Page, my lord, 599 of volume 3 paper. Volume 3 tada. Malad question, Malad page 590. Acha baat kor.
Page
599. একটা পেন দেবে তো Malad PW 130 Daman Prasad বিশ্বাস, then SDGM Ranaghat on PW 138 Tapan Kumar Das TTI Ranaghat have deposed that on 13/4/2004 you have made confessional statement before the Daman Prasad বিশ্বাস PW 130 voluntary in this case, and same was recorded under section 164 of CRPC. The confessional statement made by you has been collectively marked exhibit 172, and your signature on the recorded statement have been collected marked exhibit 172 by one. What do you want to say about this, sir? Police had beaten me at the police station and asked me, well, he arrested in another case. My lord, thereafter, soon arrest, he was taken into police custody. My lord, thereafter, my lord, this
incident happened. Police had beaten up me, police station, and asked me to make all these statement as my confessional statement. Otherwise, the police threatened to kill me. I have made the statement as I tutored. It appears from exhibit. Yes, my lord. Yes, yes, my lord. It appears from 72. That is question. The next question. It appears from exhibit 172. Your confessional statement recorded under section 130 of Daman Prasad Biswas SDKM Ranaghat that on the day before occurrence, the documentary of marriage party bushes of Ismoli at about 6:30 p.m. You went to the house of Pute Sardar and found 6 persons sitting in the house. They were Chimu Sardar, Puti Sardar, Yasin Biswas, Babu Bala, Dilip Jashora, and Tikka Khan. We asked Chimu Sardar to some money as loan. They asked you join them with enable to get lot of money. But here, second appellant's name not transfer in 164(7) of Kurban Ali. Lodhai. Kurban Ali's 164 statement, participation of Lodhai or presence of Lodhai, no indication. So far, Kurban Ali's 164 is concerned. At the time of Chimu's vote, you a firearm and 2 round ammunition. They asked you to meet them, Pute Sardar's house next day on 7:30 a.m. What do you want to say about this? Police has taught me all these things, which I have stated. Thereafter question, my lord, kindly go through answer. Sir, police taught me all this. Thereafter, police tutor all these things to me. In your confessional statement, thereafter question, I have made the statement as taught by police. My lord, regarding whole entire 313 based on, my lord, this portion regarding 164 statement, I made the statement as taught by police. Thereafter, again, my lord, regarding confessional statement, page 602, 603, answer kindly, police had taught me all these things and I have stated them before the magistrate. Thereafter, my lord, next question, police tutored me all these things. Thereafter, police taught me state all these things. Thereafter, next, same answer 1604. I made statement and thought by police. 605 also same. 606 also same. Kindly go through the answer. And my lord, 607 also same. 608 mono same up to
609 pages.
yes 610 also. I do not know. My lord, 609. Yes, my lord. Thereafter, I do not know anything about the incident. Other question. This is relevant of no other evidence, no corroboration. Yes,
Kurban Ali Mondol.
so far Kurban Ali Mondol is concerned.
So 313 is of Kurban Ali Mondol.
Kurban Ali. এটা my lord, in this regard, my lord, so far this 164 statement and Kurban Ali Mondol, my lord, sole 164, no corroboration, nothing.
This is
I relied, my lord,
Kurban Ali Mondol's 313 is up to page.
My lord, up to, my lord, page one of this relevant portion.
No, page.
Entire. No.
Question numbers are not given there.
No, this is the problem. Yes, ma'am.
616. Okay, I got it. 616.
এরপরেই শেষ হয়ে যাবে। Yes, my lord, 616. My lord, in this regard, I am relying 2 judgment. My lord, I have my lord, already my lord, annexed with the my lord, compilation. My lord, judgment relying 2003. last page of my, with the written notes.
With the written.
Written notes দিয়ে দিলাম একটু। Oh,
Which one?
my lord, 2003 Supreme Court cases 21.
Last judgment.
Last two judgment. Last two judgment, 2003, my lord, last page of my written submission. Last page. But before judgment, I have answered.
2003 volume 3.
Page 60, page 60, yes. 2003 SCC, my lord, 21 and 2004-7 SCC 77.
As far as 2003 is concerned, which paragraph you are referring to?
Yes, my lord. The board. Disney এটা annex করিস না? ও আচ্ছা। এটা 2003 27 and 22 and 29.
27, 29.
30 and
Paras 13.
my lord, 30 para, my lord, para 27, 29 and 30. My lord, para 27, may I read out? With regard to the judicial confession made by the accused person, Puran Singh, to the judicial magistrate, there are many striking features casting great doubt on the genuineness of the extrajudicial confession, which was retracted in writing by the accused person Puran Singh in the course of his examination under section 313 CRPC. The accused person Puran Singh was also arrested along with the co-accused under arrest memo such and such. His extrajudicial confession was recorded by the judicial magistrate PW1 on 9/4/84 when he was produced handcuffed before him in police custody. The fact of the Puran Singh was produced handcuffed in police custody on 9/4/1984 has been admitted by the judicial magistrate on PW1 in statement made by him in cross-examination. If Puran was in police custody in accordance with the requirement of section 164 CRPC, the magistrate should have taken care and ascertained there had been to a third-degree method used by the police against him, extra confession. The magistrate in deposition does not say that he cautioned the accused Puran Singh and the later confirmed that he was making a statement voluntary without a pressure. Here caution has been given by the learned magistrate. But there is no other corroborative evidence, no other evidence against Malad Kurban Ali. Here, Malad, other evidence also there. Whether any physical and mental pressure was put on him by the investigating officer, the first precaution that the judicial magistrate, Malad, here, so far caution and Malad segregation is concerned, that was discussed. But in essence, before proceeding to the record, the confession and statement, a searching inquiry must be made from the accused as to custody from which he was produced and the treatment he had been receiving in such custody in order to ensure that there is no scope for doubt of any sorts of extraneous influence proceeding or source interested in the prosecution. There is no verification on that particular time that he received injury or not. That was not reflected any Malad 164 statement or other. And Malad thereafter Malad 29. The confession is also not recorded in question and answer, from which is the manner indicated in the criminal court rules. The confession was retracted before the trial judge by the accused person Puran Singh on 28/7/85, where he disclosed that he was produced for judicial confession by telling him that he would be a prosecution witness as an approver. It was it is also stated that the police had met him in the jail and his signature was obtained on a statement. It appears that the accused Puran Singh was in police custody when he was produced handcuffed and recording the judicial confession. The judicial magistrate had also admitted in his statement that he was produced by the police through police station Dabod, and after recording his statement, he was given back to the custody of police. There was therefore every possibility for the accused Puran Singh to have been physically and mentally pressurized for giving a judicial confession on an assurance that he would be made a prosecution witness as an approver. He was retracted his confession before the court on 28/7/85 in course of the trial and gave a statement in writing for retracting the judicial confession on 5th August 85. In his examination as an accused after trial under section 313 CRPC, in his statement in writing under section 313 CRPC, he stated that he was physically tortured and threatened by the police to agree to giving a false confession. Here, my lord, also he has been threatened and my lord produced before the London magistrate and confessional statement has been recorded. My lord, it has been held that there was custody of the accused Puran Singh with the police immediately proceeding the making the confession. It is sufficient to stamp voluntary is unreliable. More so, when such confession is retracted, it is not safe to rely on the such judicial confession or even treat it is a corroborative piece of evidence in this case. When a judicial confession is found to be not voluntary and more so when it is retracted, the absence of other reliable evidence, the conviction cannot be based on such retracted judicial confession. Thereafter, next, my lord, 2004-7 SCC 779. My lord, 21 and 23. Para. The decisions of Court of Chandrakant Kimalal Desai, State of Gujarat, has created some difficulty in understanding the law in which otherwise so well settled. The learned judge imported the over-version which were made in Kashmira Singh versus State of MP in the context of evidentiary value of the confession and co-accused and applied them to the case retracted confession. It appears that the learned judge went to the head note in the air which opens up with the sentence and the confession of an accused person. However, in the text of the judgment is crystal clear that the entire decision and statement of law was only with the reference to the confession of the co-accused, while clarifying that the confession of the co-accused is not evidence in the ordinary sense of terms as a point out of the Privy Council. The court observed the Kashmir Singh's case. Such confession cannot be made the foundation of the conviction and can only use in support of the other evidence. Thereafter, my lord, in Chimalal case, the learned judge, after referring the head note portion, Kashmir Singh and AR 1952 S2, proceeded to apply the state application to the confession of the accused to a case retracted confession. The court observed such and such. The High Court has, on the other hand, made this confessional statement as the basis and has then gone in search of corroboration. It concludes that the confessional statement is corroborated in material particular by the prosecution witness without first considering and marshalling the evidence against the accused, excluding confession altogether from the consideration, as held in the decision cited above only. If on such consideration on the evidence available other than the confession, the conviction can safely be based, then only the confession could be used to support that belief or conclusion. In view of the error and comprehending the scope of the decision in Kashmir Singh's case, the decision in Chimanlal case falls close to the category of decision rendered per inquiry. If followed, it would run counter to a category of coordinate bench decision and larger bench decision is Pierilal versus State of Rights. Malad, here there is no other evidence, no corroborative evidence against Malad Kurmanal. Only 164 statement. So far Malad Kurmanal is concerned, this is my submission. And so far Lodhai is concerned.
His confession was made by Kurban Ali.
Yes. Yes. Confession বলে দিচ্ছি এখানে এতে লেখা আছে
স্যার এক্সিবিট হচ্ছে পেজ 98 of exhibit 5 page 82 of exhibit 5
Page 82 of Exhibit 5, the confession.
exhibit 172
Yes, 172. Exhibit 172. Only this evidence, nothing more, nothing. No, judge, only based upon the 164 statement, entire conviction has been given to Kurban Ali under section 395, 396. And thereafter, my submission in respect of Lodhai Sardar and Malad Lodhai Sardar. So far Lodhai is concerned, against Lodhai, there is recovery of one silver ring and so far Lodhai is concerned, so far recovery of silver ring, and victim statement, victim evidence, PW 59. So far PW 59 is concerned, so far recovery is concerned against Lodhai, only 3 evidence, 2 evidence when it was from his finger or it was cut, subsequently it was seized. So far PW 34 and PW 52. No other witness against Lodhai.
34 and 59.
52. 34, he is a driver of a police car. He is driver of a police car, and 52 who actually cut the silver ring. PW 52 does not identify that silver ring. If you gone through the cross-examination of 52, that was not identified by PW2 independently. So far 34 is the police personnel attached to driver of a CID office and so far independent witness who actually cut the silver ring. He my lord, could not identify that ring. My lord, that portion 52 এর evidence about the chat koro PW1 টা cross examination টা দেখা একটু দেখিয়ে দিই।
ওই দুটো ফাইল তোলো, ভলিউম 2 ভলিউম 3 টা তুলে দাও,
52 টা বার করো।
এখানটা রাখো, ভলিউম 2 আর ভলিউম 3 করে দিচ্ছি। ভলিউম 1
My lord, in chief also. Oh, my lord, volume 1. Volume 1. Page 278. My lord, in chief.
Apart from the confessional statement,
Nothing.
in the 313 examination,
Yes.
any other thing has been reflected?
So
The
far
questioning was-
164. So far 164 is concerned. Or actually, he was arrested in another case. Thereafter, he produced non-appear on behalf of Kurban Ali. Subsequently, legal aid advocate, lawyer of the legal aid panel.
Is that?
Yes.
But
Yes, ma'am. Yes.
Is that apart from so far as incriminating elements are there?
Nothing. Nothing.
One is 164.
Only one.
The prosecution case.
Yes.
What are other incriminating materials? First question. Second.
There is no other evidence, no other evidence corroborative. That's why I narrated before your lords. No other, only single evidence, kindly produce against Kurban Ali. One single evidence, he was present or he was identified, recovery was made. But this type of figure was there, Kurban Ali's figure, same time of person. No other name uttered by the 138 witness. No named uttered so far Kurban Ali is concerned.
Because he is an unknown assailant.
Yes.
He is an unknown person. Name
Yes.
cannot be made. That is separate issue.
No other witness, any name or police personnel or any evidence. So far 164, remaining 164, there is no other evidence. That's why I narrated. That's why it's totally, if your lordships also, came into conclusion, this is very dangerous. So far, only 164 statement. No other corroborative, no other single piece of paper. Nothing.
That is so far as Kurban is
Kurban is concerned.
Your argument is in respect of Kurban only.
Kurban, no, so far Kurban and Lodhai, two accused person, two appeal was paper. My lord, in respect of Kurban and Lodhai also appeared from the state legal authority. I am appearing on behalf of state legal authority.
Representing Kurban and
Kurban Ali and also Lodhai. That's why first part Kurban Ali I have already completed. But no other evidence so far Kurban Ali.
What did the trial judge say as regards that?
So 164 statements, relying the 164 statement. Kindly go through the judgment passed by the learned court below.
Show us that
Yes.
portion.
Yes. The paper book sheet about. Asked my learned friend any evidence so far 164, my lord, except 164 any evidence. Asked my learned friend, he is appearing for the state.
Yes, we shall ask.
পেপার বুক এটাই হবে কি আছে বলো কি বললাম ও জাজমেন্ট আচ্ছা আচ্ছা বলো পেজ inner page 46 running page 735
Yes.
middle paragraph. It appears from the lower court record that the case was committed to the learned session judge Nodia on 20 accused person at the time case was pending for the further investigation against Yasin Bishas, Kurban Ali Mondol and Tikka Khan and Hatim Ali Bishas. Except Kurban Ali Mondol, all are acquitted, not placed before trial court. দেখে নাও তো একবার বাকি তিনজন প্লেস হয়েছিল নাকি ওর জাজমেন্টটা পাঠ করে pending for was produced on 31st March 2004 on the basis of production warrant. He was custody of a Howrah district correctional home. Supplementary charge sheet was filed subsequently against 5 accused persons, including accused Kurban. PW 130, the learned magistrate stated that the accused Kurban was remanded in police custody on 31st March 2004 with a direction to produce him on 13/4/2004, but he was produced on 12/4/2004 with a pair of IO for recording his confessional statement under section 164 CRPC. The learned magistrate also mentioned about the order dated 12/4/2004, the lower court recorded there is a mention there that the concerned magistrate ascertained whether the accused Kurban Ali was manhandled by the police while in police custody. The confessional statement has been recorded exhibit 172. It appears from the statement that the learned magistrate had mentioned as follows, such and such. Accused Kurban Ali Mondol produced on such and such arms act. Thereafter, CR also produced. Sri Vishwas identified the accused. I asked Sri Vishwas to leave my chamber. On perusal of the CR, I find that the accused was produced first on 12/4/2004 before Sri Vishwakarma, learned JM second court, recording statement under section 164. The accused was under segregation and produced today before me after segregation. I disclose my identity to the accused and the fact I am judicial magistrate, not a police officer, and he is not bound to make any confession before me, and he makes such statement to the same may be used against him and he may be convicted as a result of such confession. The accused expressed his willingness to make confessional statement even after statutory warning. He was placed on judicial custody for segregation and reflection on the direction of the produce on 13/4/2000. There is a segregation and also caution is there. So far 164 is concerned. No doubt about it. I have already stated. The accused expressed his willingness to make confessional statement voluntary. The accused is cautioned and explained the matter content 164(2) CRPC. Once again, but he again wanted to make a confession voluntary. As such, his confession is recorded on the following verbatim words. Then the learned magistrate started putting question against noted and replies in Bengali. Learned magistrate gave him statutory caution. The accused informed learned magistrate in reply that he was kept in jail segregation and that till his production before him, no police officer met with him and also did not tell him make statement. He also replied that he was confession voluntary. And no, and none told him to assert him and gave assurance of any statement is made, he will acquit it. It appears from the statement made by the accused Kurban Ali Mondol that he stated that On the previous evening, the incident of bus dacoity at Ismoli, about a year ago at about 6:30 p.m., he went to the house of Pute Sardar while returning home from his work and found 6 others, namely Chimu Sardar, Pute Sardar, Yasmin Mistras, Babu Bala, Dilip Joshua, and Tikka Khan. Those persons were preparing gaja. He asked Chimu Sardar for some money as loan, and when he told him accompany them and also he could earn lot of money, thereafter he had some conversation with them as appears from the statement. On the following day at 7:30 a.m., he went to the house of Pute Sardar as agreed and found those people sitting there. Then Pute Sardar took knives and axe and spade and one khunta with him, and they all went to the Satberia station and thereafter came to Ranaghat. He also stated how they passed the daytime. It also appeared that at 10:11 p.m., they bought weeks on the road and near the house of construction. About 5 minutes thereafter, one three-wheeled vehicle came from the side of the Asmoli Bazaar. The vehicle stopped there and Chibu Sardar ran towards the vehicle and asked the driver to stop, started showing his machine, touching his head, and driver stopped the start of the vehicle. Chimu Sardar took away 300 and 350 from driver, then were other passenger to the take vehicle home to the hood and he remained inside the cabin. Chimu told him that Tikka Khan and Dilip Joshua to guarded those people. Then 2 others were also coming by bicycle. Chimu, Pabu and Yasmin snatched our belongings and kept them on the said vehicle. Thereafter, they again snatched away belongings. 2 other persons who came by cycle detained them. He also stated 15-20 minutes.
Yes.
Thereafter, he stated the entire incident. Thereafter, learned advocate for the defense submitted that learned magistrate did not verifying whether there was any mark of injury on the person of Kurman Ali who made statement, though retracted, and he was not asked about his lawyer. The accused was produced before the learned magistrate is Vishwakarma that he did not caution him. Before PW 130 recorded statement, but did not caution him, and as such the statement no value or eye of law, which also required corroboration. But from the evidence of learned magistrate, it appears there is a caution. Caution is there. The evidence, police custody, it is true that there is no mention in the statement in evidence whether the accused was given legal aid or not, but reason to statement cannot be rejected. The evidence of 130 statement mark exhibit 172 clearly shows that London magistrate time again cautioned him and required under the law. The statement appears to be voluntary, but no query regarding malady injury is concerned. But it is retracted confession in the decision reported such and such, page such and such. It has been stated para 116 that the value of the retract confession is now well known. The court must be satisfied the confession at the first instance it is true and voluntary. Caution and prudence in accepting retracted confession is an ordinary rule. Although if a retracted confession is found to be corroborated in material particular, it may be the basis of the regarding the incident. It appears from evidence PW1, PW1 declare hostile, PW1, PW4, 6, PW21, PW22, এগুলোর মধ্যে কারা কারা declare hostile আছে একটু বলতো? এই যে সাক্ষীগুলো আছে সব declare hostile. The first miscreant snatched away cash from the driver of the three-wheel vehicle and kept its passenger inside the cabin of the vehicle. Thereafter, 2 persons came to the cycle and there were also stopped their cash and other articles were snatched. Then again 2 persons came cycle and had to stop their cash and article were snatched. Then came the bus and bridal party, driver of whom was murdered. Thereafter, another bus came to the bridal party and behind the bus, another Tata Sumo car and stopped. The miscreants snatched away cash, ornament and other article from them. I also find corroboration of this fact from the passenger both the buses who deposed in the court through turn hostile. Malad, Malad 146, 44, 45, 95 to that. 95 hostile. All are hostile. Out of Malad, PW 21 and PW 20. There is other Malad, there's several Malad witnesses declare hostile, and also others victim, 4 victim ladies concerned, they declare hostile, does not support the prosecution stories so far rape. Rape is concerned and others material. It has been proved beyond reasonable doubt by the prosecution, the accused Kurman Ali along with other accused person in this case 1:20 AM on the intervening night 5-6 February 2000 at the road within village Asmoli PS Dhantola committed dacoity in the buses of bridal party and thereby committed an offense punishable under section 395 Indian Penal Code. And prosecution has also been able to prove beyond reasonable doubt that the accused Kurman Ali Mondal along with co-accused person at the 1:20 AM on the intervening night 5-6 February 2003 committed dacoity in the buses of bridal party on the road within village Aismoli Dhantola PS, and in the course of commission of same dacoity, one Somir Ghosh, the driver of bus number, was murdered by one of the accused person and thereby committed an offense under section punishable 396 of the. This is against Kurmana, Sopal Lamed judges. Sopal. Material, but substantial. যেহেতু 160 করতে কি দুটো উইটনেস কে এনে দেখিয়ে দিই এগুলোকে সাপোর্ট করছে 160 করে দিতে পারে ও সেইগুলো ফ্যাক্টর নিয়েছে আমি রাস্তা তারপর কোথাও লোকটাকে আমি শিখতে পারছি কখনো তার মানে বাকি যে কথা সেটা ডিসকাস সুপ্রিম কোর্টের PW 21 and 22 and other witness. My lord, in court also, yes, my lord. Yes, my lord. In court also, my lord, this witness, my lord, did not identify Kurmanan. He was present at that time. But that witness, my lord, all witness, any name uttered, so far Kurman Ali is concerned. No. No, now matter for it.
Who were turned hostile? PW 1, 2.
Manot PW1, Manot should I?
146.
Manot 146, 44, 44.
এই জয়ন্ত
না
আচ্ছা
95 hostile.
1 থেকে 1 থেকে 4 1
সেজে বুঝে আসতে কি বলে তো? সেজে বুঝে
তারপরে এটা আগের পরে ভলিউম 2 তে পাবো অনেক page 39 PW1
বলছি তো। আর সব তো মুখ চাপাচ্ছে। না না, তারপরে কাপড়ের মুখটা ঢাকা ছিল এটাও তো ওয়ানটাতে সবাই বলেছে, সবাই বলেছে। Page 3, my lord, he declared hostile, does not support the prosecution story. Thereafter, my lord, statement have been. PW10. PW10. সেইটাই দেখাতে চাইছি। সেই জায়গাটা একটু পারবো।
You did not cross-examine.
Yes, my lord.
No cross-examination was there on behalf of Kurban Ali.
Yes, my lord, no lawyer actually appear. Legal aid lawyer appear on behalf of
You are also
Kurban Ali.
legal aid lawyer. Don't
There
say
is
that.
no name.
You are also legal aid lawyer.
My lord, at that time, first, my lord, no lawyer appearing on behalf of Kurban. Well, all witness does not name any name of Kurban Ali. আইডেন্টিফাই করবে তো এই লোকটা ছিল তাহলেও তো বলবে এই লোকটা ছিল
চ্যালেঞ্জ করে স্টেটমেন্ট চ্যালেঞ্জ না করে
Well, kindly go through the entire evidence, nothing. Well, these persons was present at the time of document. No witnesses. These persons was present, that's all. My case will. He was identified, he was by the, well, all evidence. And no name uttered. Any of the witnesses. And no search seizures was also conducted. Not placed on TI parade. Compulsive 164 and conviction was made by the Lord. So far, Kurman Ali is concerned, your lordships got it. কিছু না, একটা নাম, দেখা যাচ্ছে। আমি নিজের মামলায় না, শুধু লিগাল এডের বলে এসেছি।
PW4 failed to identify you. I do not know the accused Kurban Ali Mondo.
PW4 identified.
Did not identify.
Yes, my lord, nobody identified. Nobody that he was present.
But he said that face was
All witnesses.
face was
Face was covered.
Face was covered.
That's why my lord, TI parade also my lord is a totally my lord, doubtful. Entire my lord, entire prosecution witness says on the very particular day, my lord, face was covered. My lord, except PW59. Victim. My lord, so far 59 is concerned. My lord, he was placed on, she was placed on, my lord, medical examination. There is no allegation so far rape is concerned. And no, my lord, 161 statement recorded by the investigating officer. Other, my lord, victim lady, my lord, 161 was recorded by the investigating officer. So far 59 is concerned. No 161, no 59. He was placed on TI parade. She was placed on TI parade and identified only Lodhai and Pute. Lodhai and Pute, and he vividly describes, she was no marks of injury on her private part. How far believable so far victim is concerned? मतलब कुर्बाনের এভিডেন্স গুলো দেখছে ওই ইন্ডেক্স গুলো But should I start so far Lodhai is called Kurban Ali is your lordship. If you've gone through, there is no whisper so far. Go through the entire evidence of that evidence. No, my lord. So far Kurban Ali is concerned. No, my lord, whisper. No. Well, so far,
No, the facts goes that he met with some persons at a particular place prior to the date of the incident. And again at the morning, they went to the place about
as
7
per 164. As per
right, but those persons who have been named by Kurban, that I went to their place, what is the evidence of their part? Have you checked up?
They are acquitted from this case. Other accused persons.
They may have been acquitted. What
Yes.
was there was examination of those persons.
No, those are the accused persons. That's why no evidence of Kurban Ali is concerned. my lord, co-accused statement is no, my lord, evidentiary value. Your lordship knows very well. And they have not mentioned about who. And other accused person statement, my lord, so far Kurman Ali is concerned, no name, no name.
Yes.
My lord, so Kurman Ali is concerned, any question, my lord?
Yes, yes.
Yes, my lord, there is no.
Want to point out anything else?
No, only 160.
My lord, I only
আরে লোধাইটা বল একটু বলতে দে এতদিন পরে আমি বলার সুযোগ পেয়েছি মানে so far in respect of Lodhai Sardar is concerned, firstly recovery of Malord silver ring which could be Malord seized and cutting it from the finger of Lodhai. One circumstances it was cut from the finger of Lodhai. And secondly, Malord deposition of PW9. 59. Malord deposition of PW 59. And also, so far 59 is concerned, he placed, Malord Lodhai was placed on TI parade, she identified, and so far identification is concerned, so far 59. There is also no allegation so far rape is concerned.
Tuntun Ghosh.
Yes, Malord Tuntun Ghosh. So far 59, Malord Lodhai was placed on TI parade, no allegations so far this accused persons, Malord, violated. And so far he placed for medical examination. There is also no whisper so far rape is concerned. And no 161, no one.
He was identified.
Yes, my lord.
Lodhai
Yes.
was identified.
Lodhai was identified by PW9, 59, PW 59. So far rape is concerned, there is no allegation that when he was identified, that man, my lord, he committed rape upon me or he violated upon me. There is no allegation. No. And also, and she was medically examined. There is no allegation so far rape is concerned.
Yes.
Malord, no other witnesses. Malord, so many witnesses, Malord, came to depose on behalf of the prosecution.
Yes.
First of all, Malord, 59 placed on medical examination. There is no allegation. And also test identification parade. So far rape is concerned, no Malord, any sorts of that type of allegation was present.
Take the mic, take the mic.
There is no allegation so far rape is concerned. কি হলো একটু আস্তে করো ভলিউমটা
Yes.
There is no allegation so far rape is concerned. And my lord, there is no 161 statement recorded by the investigating officer so far 59 is concerned. And there is no 164 statement so far rape is concerned. Victim lady, no 161, no 164. First time in court. So far rape is concerned, he stated before the first time in court. My lord, actually lady constable was examined, victim were examined by the lady constable, PW PW 136. Minimum বই দেখো না, একটা বই নেই সিআরপিসি, একটা সিআরপিসি বই দাও, এই আইপিসি, একটা আইপিসি বই। হ্যাঁ, হ্যাঁ। 136 recorded my lord, victim's statement, 4 victim is there. So far prosecution story is concerned, they are the 60, 61, 63 and 66.
60, 61,
60, 61, 63 and 66.
Yes.
60, 60, 60, 61, 63 and 66. Well, so far 60 is concerned, that to be declared hostile. 60. 60 to declare hostile. Except 60, 60, 61, 62, 63, 64, 65. Except 60.
You are speaking on behalf of Lodhai.
Lodhai.
Except 60.
Except 60. 60 the evidence. 61, 62, 63, 64, 65 and 63. My lord, 65, all are declared hostile. 61 to 65, all are declared hostile. They projected as a victim. And my lord.
Now these 59.
Yes, my lord. Yes.
Identified.
59. 59 is the, my lord, victim lady. My lord, who
was identified as a rapist.
Yes.
By 59.
In court, first time.
For the first time, right?
Yes.
Did you cross-examine her?
Yes.
Where have you cross-examined? Where there is cross-examination on behalf of Lodhai Sardar.
59 কত পেজটা বাড়ছেন?
59 আপনার যেটাতে আছে মনে আছে একদম লাস্টে।
At that time, page 159, my lord, running page 301. Running page 301 of paper book 1. All victim name is there. My lord, they are also present. Polygos, Tumpa, China, Chandana, Mamoni, and Rishika. All declared hostile.
Where is cross-examination on your part?
Yes. দেখো লোধায় হয়তো ক্লস নেই। কোথায়? নেই তো। No cross on behalf of Lodai.
Yes, it was done.
Yes, মানে?
It was done. Page 311.
So far?
Page 311.
মানে 311 so far PW 60.
Cross examination is there. 59 cross examination of 59. No.
59 cross
60,
examination.
sorry, sorry.
60, yes. মানে 60. মানে 59 start from 301 and মানে cross start 304. লোদাই শব্দ দিয়ে ক্রস হয়েছে এই তো এখানে আছে মানে ক্রস মানে এন্টায়ার ক্রস এক্সামিনেশন মানে লোধাই আছে লার্নেড অ্যাডভোকেট অ্যাকিউজ শহীদুল কারিকর সুবল বাগচি এন্ড লোধাই সর্দার পুটে সর্দার কৃষ্ণ সর্দার এন্ড কুরবান আলী
Yes.
এন্টায়ার ক্রস এক্সামিনেশন one of first time other all witnesses the miscreants were malad covered by cloth. One of first time a PW9 stated that the face of all those miscreants were not covered by any cloth at that time. No other witness this fact supported by the prosecution.
Where is that?
Malad cross-examination 304. First time he stated.
Yes.
No other witnesses malad stated that
Faces of all those miscreants.
Yes.
Were not covered.
yes by any at that time. All witness stated there is face was covered. My lord, kindly go through last portion of the my lord page 304. 304. He was not stated before the police, my lord. My lord,
I have not disclosed this occurrence.
my lord, subsequently one lady personnel came to our house, a police personnel came to our house and took me to CID office at Ranaghat, and there I have stated that incident to the police personnel. Subsequently, one lady police personnel went to my house, and at that time there was many persons in our house, so I have not stated anything to her, and so that lady police personnel asked me to go to CID. My lord, victim statement was recorded for the recording of victim statement so far rape is concerned. My lord, that lady constable PW 130 lady sub-inspector PW 137, all victim statement recorded by PW 136, 136, namely Salma Chakraborty, sub-inspector of CID. Only for the purpose of 161 statement recorded by the police personnel, she was asked to the all victim and recorded their statement. My lord, kindly go through what so far, my lord, volume 2, 136, but this, my lord, victims lady, my lord, 161 was not recorded by PW, my lord, and also her name was
No, this lady person was PW 137.
136. Salma Chakku.
At page 537.
Well, kindly come to page 537. You look, it's clear that all name is there. এগুলো কি কোন কোন বল সাথে বলে গো দেখে বলে দেন 537 second volume. All declared hostile. দেখুন
No, all declared. China declared hostile.
আরো অনেক Mallards, page 537.
Top right corner, page number.
PW 136. Also marked 171.
Second paragraph.
Second paragraph. On 5/25/2023, I examined 2003. I examined Polly Ghosh 61, Pinky Ghosh 60, Tumpa Ghosh 66, China Ghosh of village Guchiamora. I recorded the statement of this victim witness under section 161 CRPC. Polly Ghosh PW 61, Pinky Ghosh PW 60, Tumpa Ghosh PW 66, and China Ghosh 63.
69. 63, sorry.
I recorded the statement of this victim witness under section 161 CRPC. After throughout investigation, completion of interrogation, I seized the wearing apparel of Polly Ghosh and Tumpa Ghosh. No name transfer so far. This victim ladies, Tuntun is concerned. Tuntun Ghosh is concerned. No 161 recorded by the police personnel. Either Malord, he was placed on Malord, recorded under section 164 statement. Other victim lady was put. Malord, no recorded so far 164 is concerned. Because if he Malord narrated the, if she narrated the so far rape is concerned, Malord, he should be placed 164 statement, and also she should be placed 164 statement by Malord CID officer is concerned. And also, Malord, kindly go through also Malord medical examination. Within 5 days, she was medically examined. There is no allegation so far before. Malord, there is no allegation so far rape is concerned. And which manner she described so far, Malord, rape is concerned, violent or Malord, kindly go through page 307. So that injury is not Malord reflected in the injury report. It's totally Malord exaggerated. And if he actually Malord rape victim, if she Malord actually rape victim, he should be placed on 164 statement, and also Malord, she narrated the entire incident whether rape is concerned. Malord, before the doctor, nothing she said.
Whole testimony of the victim.
Malord, sole testimony of the victim, if he reliable and believable, Malord, then your lordships, Malord, rely upon the sole victim and Malord convict. Yes, Malord. Malord, other circumstances, Malord, so far rape is concerned, this victim is concerned. Malord, other victim, there is a 161 statement, 164 statement. Malord, so far this Malord victim is concerned, no Malord supported other evidence. That's why I narrated so far 376 concerned, Malord 76 is concerned. How far believable when he first time Malord so far rape is concerned reflected in the court. That incident, so far rape incident. How far believable? If he says before the doctor he was violated, she was violated, my lord, I nothing to say. She was violated on that day. And my lord, there is marks of scratch mark or injury, nothing is there. So far, entire my lord story has been narrated by the my lord PW 59. My lord, no such medical evidence supported that story. No such evidence. My lord, and not only that, this my lord allegation, she stated before the first time in court. And not only that, other victim not supported that story. Other victim, she said that this victim were with us or anything. Malad, kindly go through PW 59, page Malad 301. That Polly Ghosh, Tumpa, China, Mamuni, Risika, and others were that one. She was also present. They are also present. They are not supported so far. This Malad allegation is concerned. That's why, my lord, how far believable so far 59 concerned, rape is concerned. Judgment about what?
5.3 paragraph.
Well, in this regard, I am this is the my lord
5.3 থেকে start হচ্ছে।
My lord, I am relying 2020 part 3 SCC 443.
Page?
My lord, 443 2020 2020 part 3 SCC 443.
You have given that judgment here?
Yes, ma'am.
The first one,
The first one.
just after the written notes.
Just after the reading.
Para 5.2 onwards.
Let's go. The lawsuit's got it. Number 5 point. From the impugned judgment and orders.
5.2.
5.2. Para.
Yes.
Yes. From the impugned judgment and order passed by both the court below, it appears that appellant has been convicted solely relying upon the deposition of prosecutors PW5. Neither any independent witness nor even the medical evidence support the case of prosecution. From the deposition of PW1, it has come on record that there was a land dispute going and between both the parties. Here, when local police station, OC of that particular local police station, investigated this case, so far rape is concerned, there is no allegation so far. That's why case has been started only under section 395, 396.
No allegation of rape.
No allegation of rape. Thereafter, investigation shifted to CID. Thereafter, because they are the acquitted accused person, co-accused in this case. Actually, they agitated. Evidence it will come. Agitated so far police activity is concerned on the particular night. Each and every day there is a posting of police picket is there, and one sub-inspector and constable guarded that particular point. On the particular day, there no Malad police personnel on the particular night. That's why Malad all Panchayat Samiti member, Pradhan, they agitated against the police personnel. That's why that accused persons, those who are agitated on the particular day, they were accused in this case and subsequently tried to establish certain recovery was done and shown, and subsequently the prosecution story failed. That's why other 17 accused persons acquitted from this case. And all accused persons who are convicted, my lord,
Yes, Mr.
they are acquitted from this case. And my lord, that's why my lord, subsequently CID well, here is also my lord, same. My lord, yes, same. Yes. Yes. My lord, if my lord, so far chief is concerned of the victim girl, kindly go through that how my lord she has been violated by the my lord, if true 59 by my lord this accused person. My lord, some sign of my lord injury marks should be present in private part. There is no sign. My lord, kindly go through if you exhibit
এভিডেন্স অফ 113
এটা বার করো। না
ওখানে বলা আছে
আচ্ছা 113 এক্সিবিটটাও বার করো।
করে দিচ্ছি এভিডেন্স
মানে পিডব্লিউ
130
130 মানে ডক্টর রেডি না ডক্টর রত্না
এই তো
13
এভিডেন্সটা বের করে
বার করো না
এটাতেই আছে সেকেন্ড ভলিউমটা এটা
ওর থেকেও তো ভালোভাবে একবারে এক্সিবিটটা দেখিয়ে
এগুলোতে তো হাতের লেখা এগুলো মেডিকেল করতে বলা
মানে 465
ভলিউম 2
465 ভলিউম or kindly go through that malad portion. এইটা তো কলিগ হচ্ছে না
ও সবাইই করেছে
না টুনটুনেরটা তো টুনটুনেরটা বার কর
বলে দিচ্ছি
যেটা হবে এখানে হ্যাঁ মানে কাইন্ডলি
পেজটা বলে দিন স্যার
পেজ মালট 466
She examined Polly Ghosh.
No, then
No,
next page.
next page, 466. 466,
Fourth paragraph.
fourth para. On 7/3/2023, 2003, during my duty hours at Ranaghat SD Hospital,
Incident took place on 6/2/2000.
466, inner page, incident
Incident on
or
6th February.
see 569, 569,
When the incident took place.
Fifth and sixth night.
5th and 6th night. After 12, my lord, intervening 5th and 6th, actually 1:30 AM.
On 6th.
On
So
6th.
the case number 6/2/2003.
Yeah.
That is in 6th February.
Yes, my lord.
5th or 6th February.
Yes.
And she was examined on 7th March.
March. 1 month after. During any duty hour, my lord, on 7th,
delayed allegation of rape
my lord, because there is after, my lord,
allegation of rape.
transferred to CID, there is allegations of a rape is concern is came.
Initially there was.
Initially, there is no rape is concern, and that's why no 376 or 376G there. Mala after Mala taking over investigation by CID, that's why new story came. There is a Mala so far rape is concerned. That's why Mala after 24 days, CID took up investigation. That's why that rape story came into Mala newly formulated by CID officer. And that's why on 7/3/2023, my lord, she was examined. My lord, on 7/3/2003, during my duties hour at Ranaghat ST Hospital, I also examined one Tuntun Ghosh, daughter of Nitai Ghosh, being brought and identified by Horogobindo Kundu, ASI of Police Ranaghat DD. Before her medical examination, said Tuntun Ghosh, given her consent for the same before. On my medical examination, Tuntun Ghosh, I found whether she was raped or not cannot be ascertained at present. Her hymen was ruptured partially. No marks of violence found in her breast, lip, face, and private part. No foreign body was found in her private part. She was capable of sexual. After this medical examination of the said Tuntun Ghosh, prepared by the medical examination report on the date which my dated signature and official seal there, said Tuntun Ghosh was also signed on the medical report giving her consent for the medical examination. This is the said medical examination report prepared and signed on 7/3. This is the said signature of Tuntun Ghosh medical examination report. Tuntun Ghosh must exhibit 157 on proof without objection. Hymen of female may be ruptured partly in case of rape. Any small abrasion of body and may be held by the 7 or 10 days by the learned advocate for the accused. So it will cross-examination. Malord Soibal Bakchi, Lodhai Sardar, Krishna Sardar, and Kurban Ali. In all cases, I do not note any history. In all cases, I do not note the history of the incident stated by the patient on the medical examination report. In this medical examination report, there is no note about any history of rape of this female. No history so far rape is concerned because she did not state anything. So judgment of judgment. Malord judgment, Malord, so far this rape is sole testimony, Malord 2020, part 3, SCC criminal 443, Malord 5.2. First judgment of my written notes after the.
Yes, we have taken note of that.
Yes, 5.2 onwards.
5.23.
5.2, 5.3, 5.4.
5.4.
Yes.
5.4.2 and 1 entire thereafter. No other evidence so far corroborated the other. No. And so far, my lord, recovery is being concerned. One person is, my lord, there is a diver of a police person, my lord, police, and my lord, another, my lord, did not, my lord, identify that as a silver ring. And even learned judge also, that recovery disbelief. So far, recovery of my lord, ring is concerned, learned judge disbelief. রিটিন নোটসে বলে দিয়েছে তাও জন্য এবারে জাজমেন্ট মানে পার্ট 3